of the entire Mr. Lee, this is Mr. Gould. Good morning.
Good morning, Mr. Gould.
And you can hear me loud and clear?
Yes, sir, I can.
We're still kind of taking a passive role in this case, but we might speak up during the briefing discussion. So I just wanted to make sure you
Thank
can
you,
hear me.
sir. I
Okay,
can hear you.
okay. This is a tough case. You got the toughest job in the room.
I know.
I couldn't remember, but yesterday did the hearing examiner spell out what was meant by CERCLA?
Yes,
Okay, cool. Yeah.
I worked in federal court for a year, so I'm quite familiar with CERCLA.
Okay, cool. Yeah, that's one of those statutes that you talk to the guy in the street, he doesn't know, but if you say Superfund, they understand, you know?
Right, exactly. I
Okay.
appreciate your thoughts, Mr. Gould.
Well, I mean, I can barely pay attention on some of this stuff, and you got to pay attention every second.
That's true.
When we get into the fights about this exhibit, that exhibit, I'm just like rolling my eyes back in my head. It's like, oh God, shoot me now.
Right.
Anyway, okay. Well, have a good day.
You too.
Good morning, Anna and David.
Hey Jeff, how are you?
Doing well, thanks.
Nice.
Good morning, David.
Morning, Mr. Albright. I can hear you just fine.
Great, thanks.
Mr. Lee, Chris Sandberg, can you hear me okay?
Yes, sir.
Thank you.
You bet.
I may have an extended outing over the lunch hour here. I have to pick up my wife's anniversary gift today.
Or you're a dead man.
Well, after 49 years, I don't want to risk it. Let's put it that way.
That would be a major blunder.
Met her when I was a midshipman at the Naval Academy.
Hey, Jeff.
Oh, good morning, Joseph. How are you, sir?
Good. How are you?
Good.
Mr. Lee, this is Mary. Mr. Lee.
Ariel, it looks like David was just muted there, but we can hear you fine.
I
Thank
can
you.
hear you. I can hear you, Mr. Nancy.
Good morning. I was just wanting to remind you of the email that I sent yesterday.
That I understand.
Thank you so much.
You bet.
Okay.
You're on mute, Judge.
Okay, good morning, Mr. Lee.
Good morning.
Somehow it mutes me automatically. It doesn't want me to talk, which is probably a good thing, but all right, well, let's, are you ready to go,
Yes, sir.
Mr. Lee? All right, let's commence this seventh and last day of evidentiary hearings in this case number 21-00017-UT. We have a couple of witnesses to get to. We have at least one preliminary matter, and then we have post-hearing issues and briefing schedule to get to after that. So let's see, whom do we have for Ms. Nanazi? Good morning.
Good morning, Your Honor.
Good morning. Whom do we have for the company? Oh, there we are, Ms. Terwilliger.
Good morning.
Good morning, ma'am. Were we able to arrive at a consensus on the administrative notice debacle regarding the case 16-276, taking administrative notice of relevant portions of the record on the issue of prudence? Ms. Nanazi?
I don't know what PNM's position is at this point. You know that.
You were supposed to consult.
Hearing
Is that
examiner,
correct? Yes, ma'am.
PNM does not object to any exhibits 26, 29, 30, and 31 coming in to the record. Those were the four that were identified yesterday. We went and reviewed them, and we do not object to any exhibits 26, 29, 30, and 31.
That Thank you very much. That's a reasonable accommodation on PNM's part. PNM didn't need to do that given what brought us to this point, but in any event, I'll let that sleeping dog lie here next week to me. Well, he was a little while ago. Anyway, literally and figuratively. But so with that, is there any objection to the admission of NEE exhibits?
Could you try again?
Sorry, that was Siri talking to me there. Is there any objection to NEE exhibits 26, 29, 30, and 31 being taken administrative notice of, or being admitted as administrative notice being taken of those exhibits? Hearing none, NEE exhibits 26, 29, 30, and 31 are admitted. That doesn't completely resolve, however, the administrative notice issue, because there was some confusion I felt when we discussed the matter around what would be done in terms of taking administrative notice or citing, at least citing to the certification of stipulation in 16276. Now, this runs counter to my judgment on taking administrative notice of the recommended opinion and order, the so-called RU of the Arizona Corporation Commission administrative law judge that was part of my order addressing pre-hearing motions. However, I feel that there are special circumstances, and there are always exceptions, right, that call for a different treatment. And therefore, I'm going to propose the admission, and hereby am proposing the admission of Commission Exhibit 1, which I've placed in the Dropbox folder. And that is the certification of stipulation issued October 31, 2017 in case 16-276-UT, taking administrative notice of it and placing it in the record pursuant to 1.2.235D, as in David, 1D in MAC, that allows discretion to take administrative notice of decisions, records, and transcripts in other proceedings. And moreover, more crucially than that even, is the commission's instructions to the presiding officer, effectively in the, not expressly to a presiding officer, but stating pretty clearly that the commission, quote unquote, states in the subsequent proceeding, administrative notice will be taken of the evidence of the issue of prudence admitted in the current proceeding. As we discussed ad nauseum yesterday, that evidence is most of it is cited in the certification of stipulation. Is there any objection to taking administrative notice and admitting Commission Exhibit 1?
Hearing examiner, this is Debria Twilliger. There's no objection, but PNM preserves its right to argue in the briefs the legal significance of the certification of stipulation.
Precisely and well said.
Thank you.
I don't find that statement offensive at all. I just wanted to try and finally clear up that mess. But thank you for that non-objection statement. Is there any other objection or any other statement regarding the certification stipulation? Ms. Nazi?
No, thank you.
Okay. Well, you're welcome. All right, Commission Exhibit 1 is admitted. Now let's move to the final two witnesses in the case. Ms. Nazi, I believe your witness is up first. Would you please call your witness? Thank you.
Yes, thank you, Mr. Hearing Examiner. Mr. Lee?
Mr. Sandberg, would you raise your right hand, please? You solemnly affirm that the testimony you're about to give in the matter and opinion should be the truth, the whole truth, and nothing but the truth?
You cut out partway through, but assuming it, you said that my testimony will be the truth, the whole truth, and nothing but the truth, I do so affirm.
Thank you, Mr. Lee and Mr. Sandberg. Good morning. Mr. Sandberg, could you please look at what's been marked New Energy Economy, Exhibit 5, the direct testimony and exhibits of Christopher Sandberg on behalf of New Energy Economy on July 12th, 2021. Do you see that document?
I do.
Did you write this document?
I did.
And if you were asked these questions today, would your answers be the same?
They would.
Your Honor, I'd move for admission of Exhibit NE, Exhibit 5.
Is there any objection to the admission of New Energy Exhibit 5?
No.
And
I can
sir,
just vote.
thank you, Mr. Hearing Examiner. And sir, would you look at NE Exhibit 5A? This is the exhibits to,
I haven't admitted Exhibit 5 yet.
I'm so sorry.
I was about to. Thank you. New Energy Economy Exhibit 5 is admitted. Partly, Ms. Namazi, I'm not very fond of NE as the calling it the acronym, so that's why I kind of paused too. I do have reasons for it, but I was trying. I was almost going to say it, but I just said I'm not quite there yet with that acronym, so sounding it out that way. But go ahead. So you wanted to talk about 5A now.
Thank you, sir. Mr. Sandberg, New Energy Economy Exhibit 5A are the exhibits to the direct testimony that we were just talking about that was filed on your behalf on July 12th, 2021. Are these the exhibits that were filed on the same day with your testimony?
They are.
And are they the exhibits that you mentioned in your testimony and that you put together as part of your exhibit list?
Yes, ma'am.
Mr. Hearing Examiner, I would move the admission, of New Energy Economy Exhibit 5A.
Any objection?
No, hearing examiner.
And
New
lastly,
Energy. This time you didn't give me reasonable time to move it. So you want to move on to 5? You want to move on to your next one, and I'll just leave that one.
that's what I was thinking.
No,
but
no. I think you probably should allow me to admit it. Otherwise, it won't be in the record. Otherwise, if you'd rather, just go ahead.
please,
Please what?
please.
Admit your exhibit. Okay. New Energy Economy Exhibit 5A is admitted. Next, Ms. Namazi.
Mr. Sandberg, could you please look at New Energy Economy Exhibit 6?
Yes, ma'am.
Is this the rebuttal testimony of Christopher K. Sandberg on behalf of New Energy Economy filed on August 2nd, 2021?
It is.
And did you prepare this testimony?
Yes, I did.
And is it true and accurate to the best of your knowledge and ability?
Yes, ma'am.
And if I asked you these questions, would you give the same answers today?
I would.
Mr. Hearing Examiner, I move the admission of New Energy Economy Exhibit 6.
Any objection to that exhibit?
No, hearing examiner.
Hearing none, New Energy Economy Exhibit 6 is admitted. I think I know what maybe the problem is, Nanazi. You're ahead of me on coffee or whatever other stimulant. So.
I wish I could show you my tea, but I only have drunk this much. So may I proceed, Mr. Hearing Examiner?
Yes, ma'am.
Thank you. Mr. Sandberg, I am tendering the witness for cross-examination.
Thank you. All right, we have up first PNM. And Ms. Terwilliger, what did you have? You had 72 minutes according to my calculations. Does that sound about right?
That's right. A random number, but that's right. Thank you.
Okay, please proceed.
All right. Thank you, hearing examiner. Good morning, Mr. Sandberg. My name is Debria Twilliger, and I'm counsel for PNM. Can you hear me?
Yes, ma'am.
Okay, thank you, sir. I will be referring to just your direct testimony today, NEE Exhibits 5 and 5A. Is that understood?
Yes, ma'am.
Okay, I just want to be clear what your testimony states, Mr. Sandberg. You oppose PNM's abandonment application, is that correct?
Yes.
And you believe that PNM should remain in Four Corners for now, is that right?
No.
If you oppose PNM's abandonment application, how is PNM to exit Four Corners, Mr.?
You misinterpret my testimony.
So you believe PNM should exit Four Corners, but have its abandonment application denied?
You're proceeding from a false assumption that undermines all your questions.
Okay, so let me ask you this. So what you believe you believe or you object to PNM recovering any of its costs associated with Four Corners. Is that right?
Through the vehicle that PNM has attempted to use here, which is inappropriate and contrary to state law, yes, I do.
And you believe that the cost associated with Four Corners power plant should be taken out of rates as soon as possible, if I recall your testimony correctly?
Yes.
Okay. Turn to page 7 of your testimony, will you? I'm just trying to understand what you relied on to draft NEE Exhibit 5, if I might. So you reviewed PNM witness testimony and exhibits, supplemental and rebuttal testimony in this case? Is that right?
At the time this was prepared, I had read the pre-filed direct and supplemental testimony, which is all that existed.
Sure. You've reviewed rebuttal testimony as of now. Is that right?
I didn't understand the question. No, you faded at the end. I'm sorry.
You have reviewed rebuttal testimony as of now. Is that right?
Yes, ma'am.
Okay. And I assume you reviewed all the responses to New Energy Economy's discovery request. Is that right? PNM's responses to NEE's discovery request. Is that right?
I would believe well, this has been a somewhat protracted proceeding, so I'm not prepared to say that I read every single word of every single response, but I believe at the time they were returned that I did review them.
Did you review PNM's responses to Sierra Club's discovery request?
I do not recall whether I did or not.
Okay, and you reviewed the orders from case number 16-00276-UT, which is a 2016 rate case. Is that right?
Are you referring to the two commission orders in that case?
I'm referring to the certification of the STIP and the final order from the commission.
Well, there was a certification, then there were two subsequent orders that I'm aware of.
And you reviewed all of those orders?
Yes, ma'am.
Okay, and in fact, you summarized the hearing examiner's findings in the certification of stipulation at page 12 of your testimony. Is that right?
It begins at page, hang on, scrolling. Begins at page 12 and continues on to the top of 15.
And then you concur with the hearing examiner's recommended findings in the certification of STIP that PNM's decision to remain a participant in the Four Corners power plant was imprudent. Is that right?
Yes, ma'am.
Okay. And you came to the conclusion, this concurrence with the hearing examiner's certification of stipulation by reading the certification of STIP. Is that right?
Yes, ma'am.
Okay. And did you verify any of the analysis conducted by New Energy Economy witnesses or other witnesses in the 2016 rate case to arrive at your concurrence?
If your question is that I go back and dig up testimony that preceded the hearing examiner's plural possessive recommendation, no, I did not.
Okay. And so you didn't review any of the New Energy Economy exhibits in that case either, did you?
I'm hesitating to answer the question yes or no, because it is possible that materials that New Energy Economy may have used in that case, I may have seen in some other context rather than just seeing them as an admitted exhibit in the 16 rate case.
Okay. So during the vast majority of your career, you worked as an attorney, is that right?
Yes, ma'am.
All right. You're not licensed to practice law in any jurisdiction right now, is that right?
Yes, ma'am.
And you've never been licensed to practice law in New Mexico?
Yes, ma'am.
And you've never testified as an expert in a utility resource abandonment proceeding before this, is that right?
It is correct, but I disagree with the characterization of this proceeding.
Okay. You've never performed resource planning modeling in your career, is that right?
Yes, ma'am.
And you've never used any resource modeling programs such as Strategist, is that right?
Depends on your use of the term have I used. I have certainly worked with witnesses who are using Strategist, and I have looked over their shoulders quite literally, as well as discussed with them what they were doing and how they were using that same program. But have I run a Strategist analysis personally? No.
Okay, thank you for that answer. You have no experience in coal plant operations, is that right?
I have never run a coal plant.
Okay. You do not claim to be qualified to opine on electric system reliability metrics or utility reserve margins, do you, Mr. Sandberg?
To assign, I'm sorry, I don't know.
Opine.
Please
To
ask the question. Please ask the question again. I think I may have mangled it as I was listening to it. I'm sorry.
Sure, I will be happy to. You're not qualified to offer an opinion on electric system reliability metrics or utility reserve margins, are you?
It would depend on the depth of the opinion that was sought. My experience representing the Midwest Independent System Operator in several cases did give me exposure to an understanding of those concepts because they were critically important to the cases that my client was putting on and that I assisted with. But that's not a deep dive understanding.
It's an understanding as an attorney, but not as an expert on those matters. Is that right?
I don't know how to. Well, you asked me if I had an understanding. Yes, I have an understanding as a human being.
Okay, fair enough. And you didn't conduct any independent analysis of Mr. Graves' testimony in this case. Is that right?
As to his technical work, that is correct.
And in fact, you're not qualified to conduct the same type of assessment as Mr. Graves. Is that right?
I'm not sure what the necessary qualifications would be.
All right, we'll move on. Let's talk about the amount of disallowance in this case that you're recommending. How much of PNM's investments in the Four Corner Power Plant are you seeking to disallow in this case?
I don't believe any of the approximately $300 million that PNM is seeking to impose on ratepayers should be allowed.
Okay, so in fact, at page 11, line 21 of your testimony, you state that 271.3 million in undepreciated investments in Four Corners Power Plant are illegal costs. Is that what you say?
You've read that correctly.
Thank you, sir. And your testimony about PNM's investment in Four Corners Power Plant regarding that specifically your reference to those illegal costs, it's based on the certification of stipulation in the 2016 rate case, is it not?
As my testimony at lines 20 to 22 say, because of their imprudent acquisition, and that imprudence was a key finding of the hearing examiners in the 2016 case.
Okay, thank you. You quote the Public Service Company of New Mexico versus NMPRC Supreme Court case on page 22, lines 19 to 20.
Let me
Right.
scroll down. May I scroll down first, please?
Of course.
There are regrettably some very similarly titled New Mexico Supreme Court cases. So this is the, okay. All right, I see the quotation on page 22, yes.
And you note that the Supreme Court has determined that a disallowance should equal the amount of an unreasonable investment there. Is that right?
That is their quote.
And how much of the 271.3 million is an unreasonable investment, in your opinion, Mr. Sandberg?
Based on the fact that it was an imprudent decision to incur any of those costs, all of them should be disallowed as being unreasonable.
Okay, so when you say any of those costs, are you aware that some of that 271.3 million represents approximately 184.1 million in capital investments that were incurred prior to 2016, which translates to 61.2 million in 2024 net book value? Are you aware of that?
I have seen those figures in the record.
Okay. So you understand, I assume, that investments prior to 2016 don't include the SCR investments or the capital investments that were subject to the disallowance in the hearing examiner's certification of stipulation in the 2016 rate case. Is that right?
I believe those precede that case, yes.
So where in your testimony, Mr. Sandberg, do you opine that the investments made prior to 2016 are imprudent?
Because the investments made prior to 2016 were the result of a decision prior to 2016 for PNM to continue to invest in Four Corners.
So you understand that the hearing examiner's decision in the 2016 rate case did not disallow costs prior to 2016. Is that right?
You'd have to show me where you're coming from on that one.
Well, I'm quoting your testimony. Let's go to page 15 of your testimony. How about that? Lines 24 to 31. You have some block quotes there at lines 24 to 31 regarding the hearing examiner's disallowance in that case. Can you review that, please?
I see it.
And they did not disallow costs prior to 2016 in that certification of STIP. Is that right?
Well, the quote I have in 24 to 31 relates to SCR and life extending capital improvements. That's all it relates to.
So you reviewed, I mean, we just talked about this. You reviewed the certification of STIP. You're basing a lot of your opinions and your testimony on the certification of STIP, but you don't recall if there are any other disallowances regarding the Four Corners power plant in that certification of stipulation?
I'd be glad to go back and look through it if there's something you wish to point me to.
Well, I pointed you to your testimony, which is the disallowance recommendation by the hearing examiners. But you, subject to check, would you agree that the hearing examiners did not disallow costs that were incurred regarding the Four Corners power plant prior to 2016?
You know, that phrase, subject to check, is a wonderful minefield for a witness, and is not something that I would ever advise a witness, including myself, to agree to.
Yeah, okay, I get that. Your attorney uses it a lot, but we'll move on. Have you demonstrated that all of the 207, so
Objection, Your Honor, to your
Sustained.
attorney. A lot.
okay,
Sustained.
thank you. Have you demonstrated that all of the 271.3 million are a legal cost, Mr. Sandberg?
In the context of this proceeding, I believe that's correct.
So you agree, I assume by your testimony you've already given, that the SCR investments are a legal cost, is that right?
Yes, ma'am.
And the life extending capital investments at issue in the 2016 rate case are a legal cost.
Yes, ma'am.
And the pre-2016 non-SCR investments are a legal cost.
Well, you're asking the same question in another context, but it is probably more efficient for me to simply tell you once again that I don't believe any of the investments which PNM is seeking to impose the costs of on ratepayers in this proceeding are being done in an appropriate manner in this proceeding.
Okay. Did you review, you stated you reviewed, I'm sorry, the PNM testimony, direct and supplemental testimony prior to filing your direct testimony. So specifically, did you review Mr. Falgren's supplemental testimony?
Given the timing that I recall of the rounds of testimony, I would, well, let me back up and look. Yes.
Okay. So in TGF 5, which supplemental, which is an exhibit to Mr. Falgren's testimony, and in TGF 6, starting with TGF 5, which refers to capital investments from January 1st, 2019 through June 30th, 2020. And then
Sorry, which refers to capital investments from
January 1st, 2019 through June 30th, 2020. And then TGF 6 supplemental, which refers to capital investments from January 1st, 2020 through December 31st, 2024. Mr. Falgren provides evidence that those capital investments were made for safety, regulatory compliance, and reliability reasons. Do you recall those exhibits, Mr. Sandberg?
I do not.
All right. And so you don't dispute Mr. Falgren's conclusions that those investments were made for safety, regulatory compliance, and reliability reasons?
I have no opinion on that question.
Okay. So, Mr. Sandberg, would you agree that the Four Corners Power Plant has been serving PNM customers since the 2016 rate case, and in fact, it's been used and useful since that time?
In fact, I think that is the core reason why the application that PNM has made here is improper, yes.
And in fact, Four Corners has served approximately 10% of PNM's customer total energy needs since 2016. Is that right?
I do not know that number, yes. I do not know whether the number you quoted is accurate or not.
Okay, well, let's go to Mr. Falgren's supplemental testimony, TGF 1 on page 45.
Are you using, so that we're using the same document? Is this PNM Exhibit 5 in Dropbox?
It is, sir.
All right, give me a second. I will open that. All right, where am I going in Mr. Falgren's supplemental testimony?
Table TGF 1 on page 45.
All right, let me scroll. Hang on. As a couple of witnesses observed last week, the danger of having too many windows open at the same time. I'm sorry, TGF, what number, please?
Table TGF 1
1. Okay, I went too
on
far.
page 45.
Yeah, I went too far. TGF 5 seems to be very large. I'm sorry, it's a very long document. 4. Two. So where is it? Okay.
All right,
I'm sorry, I was assuming that there were things attached that weren't. All right, I am on page 45 of Exhibit 5, and there's a table at the top of that page, PNM table TGF-1 annual megawatt hours. Is that correct?
and Four Corners summer equivalent availability factor in 2019 was 92% and 86.5% in 2020. Is that right?
I'm sorry, in
I-
summer of 2019 was,
92% in 2019, Mr. Lee, and 86.5% in 2020. Is that right?
I see that testimony at lines 6 to 8.
And you don't dispute that the Four Corners power plant was a critical part of providing for customer needs during extreme weather events such as the California blackouts in the summer of 2020 or the polar vortex in February 2021. Is that right?
I have no opinion on the statements made at lines 9 to 12. I see them, but I can neither agree nor disagree with them because I do not know what PNM's operations were in those summer time frames that Mr. Falgren is testifying to at lines 9 to 12.
Okay. So your testimony is that your remedy is that we get PNM's customers get ongoing reliable service from the Four Corners power plant, but no cost recovery regarding the plant. Is that your remedy as your testimony indicates?
Difficulty in answering the question as you pose it is it starts from a false assumption that this is an abandonment case that can be pursued as PNM wants to pursue it in this case.
Mr. Sandberg, if the abandonment's denied, you understand that PNM will continue running the Four Corners power plant, isn't that right?
I have no idea what PNM will do.
You understand that it has a CCN for the plant, right?
A certificate of public convenience and necessity, I assume one was obtained at some point in the past.
And so if abandonment is denied, PNM would continue to rely on this plant for service to its customers.
I do not know what PNM will do in the future.
Okay, all right. Let's talk
Since
about,
PNM is on record here saying it won't, I'm sorry, no, I will stop there. I do not know what they will do.
all right. Okay, you look at some subsequent facts about the economics of the Four Corners power plant in terms of PNM's decision in the 2013 to 2014 timeframe. Is that right? Look at about page 20 of your testimony.
Are we done with Mr. Fogden? Oh, and I ask so that I can, if possible, clear a little bit of multiple overlapping windows off my screen.
Sure.
We are?
Yes.
Okay, thank you. I'm sorry, which, my direct or something,
Yes.
or, okay, what
No,
page?
I said right from the start, we're only referencing your direct in this case.
Okay, fine. What page?
At page 20,
Okay,
you
yeah.
look at some subsequent facts about the economics of the Four Corners power plant in terms of whether PNM's decision in the 2013 to 2014 timeframe was prudent. Is that right?
I am looking at the question of whether Four Corners was uneconomic.
Okay. So in making your conclusions about whether Four Corners was economic, you cite to some power purchase agreement prices for replacement power in the Palo Verde case, which is case number 21-00083-UT. Is that right?
Yes, that's correct.
And you're familiar with that case, right?
Familiar is a slippery word. I reviewed that case to the extent necessary to identify the material that I'm using at lines 5 to 14. And I believe Mr. Falgren testimony as well, since that's also cited at 13 and 14.
Okay, so you definitely reviewed Mr. Falgren's testimony, which you cite, and you also signed a confidentiality agreement for that proceeding, right? It was posted in the docket.
Yes, ma'am.
All right. Do you know when the RFP was conducted for those replacement resources?
I don't have that in my head as we sit here today.
So you reviewed Mr. Falgren's testimony in that case, and he states that it was that the RFP was conducted June 25th, 2020. Is that right?
I do not recall that level of detail on Mr. Falgren's testimony as we sit here today. If you'd like, we can go look at it, but I don't have it in my head.
Okay. So you compare the information in the Palo Verde case, their PPA prices, to 2016 Four Corners power plant cost. Is that right? And that's the Mr., and I'm not sure how to pronounce his name, Mr. Schlissel's testimony from Citizens Group. That was testimony that was filed in the Arizona Corporation Commission docket. Is that right?
Lines 15 to 19, I'm referring to Mr. Schlissel's sworn testimony, yes.
Okay. So you're comparing
Can you spell
26.
Schlissel?
Sure, I'm sorry, Mr. Lee. It's SCHLISSEL.
Thank you.
Thank you, Mr. Lee. So for point of reference, though, you're looking at Mr. Schlissel's 2016 Four Corners power plant cost and comparing that to the PPA prices in the Palo Verde case. Is that right?
I believe Mr. Schlissel testified comparing 2016 Four Corners costs against 2017 Four Corners costs, and then 2018 and 2019. That is the quotation that is in lines 15 to 19.
But you, in your testimony, NEE Exhibit 5, are comparing his Four Corners cost to the Palo Verde PPA prices, are you not?
Can you point me to what you're referring to, please? You're going back up to earlier in the page.
Well, you cite to the Palo Verde prices, and then you cite to the 2016 prices. And I assume you're making that reference to state the subsequent facts prove that PNM's investments in Four Corners is uneconomic. I'm just looking to your testimony, Mr.
Yes,
Sandberg.
ma'am.
So are
It's
you
certain-
comparing the Palo Verde prices to Mr. Schlissel's 2016 Four Corners cost?
No, the testimony in that page compares Atrisco's price and the Jicarilla price.
I'm sorry, and
Jicarilla, Jicarilla. It states those prices and notes the significant difference between those and Four Corner prices in the range of 2016 to 2019.
Okay, so is it your testimony? Let's just focus on the 2016 Four Corner cost, if we might, which are listed as $55.45 per megawatt hour. Is your testimony that PPA prices as of mid 2020 are comparable to Four Corners cost in 2016?
I'm sorry, PPA. Are comparable. I'm not sure how you're trying to use the word comparable in that question. I'm sorry.
All right. Do you know,
I'm
Mr. Sandberg, that solar PPA prices have declined significantly between 2009 and 2019?
I'm sorry.
I'm just asking you if you know how much
No,
solar.
I'm concerned that I'm losing your sound. Could you please, I think you may have cut out at my end. Could you please ask the question again?
Sure. Mr. Sandberg, do you know how much solar PPA prices have declined in recent years?
I do not know the specifics as to solar PPAs in New Mexico. I'm generally aware that the costs of solar generation have declined.
Okay. And in fact, Mr. Schlissel's testimony, which you cite, represents that solar PPA prices from 2009 to 2019 have declined more than 80% nationwide. Is that right?
Mr. Schlissel's testimony?
Yes, which you cite at page 20 of your testimony.
I don't think I quoted anything about solar in line 15 to 19. I believe all of Mr. Schlissel's testimony that I quote there are Four Corners costs.
I know, I'm just referencing the same piece of testimony. And then that same piece of testimony, which I assumed you reviewed since you quoted it, that perhaps you knew that he made that representation that solar prices had declined about 80% between 2009 and 2019. I'm asking if you know.
I do not recall his specific testimony about decline in solar.
So, Mr. Sandberg, do you think that PNM would have been able to get the same PPA prices in the 2013, 2014, or even let's say 2016 timeframe that it was able to get in the 2020 Palo Verde replacement resources proceeding?
I do not know, and I don't think it's possible to know because PNM didn't do it.
And you understand, I assume, Mr. Sandberg, that if PNM had decided not to reinvest in Four Corners in the 2013, 2014 timeframe, it would have had to acquire or contract for replacement resources prior to 2020. You understand that?
I expect that had PNM done a reasonable analysis in that time in 2013-ish timeframe, that the 2016 rate case would have looked very different because PNM would have had to come in with a very different proposal as to its investments and as to its expenses.
Yeah, but that wasn't my question. My question is, you understand that if PNM had made that decision to not reinvest in Four Corners in 2013 or 2014, that it would have had to acquire or contract for replacement resources. Is that right?
I do not know what PNM would have done when it made a rational decision to stop investing in Four Corners. It depended on what PNM viewed as its load requirements going forward.
And
and it may well be the case that some portion or even all of its ownership interest in Four Corners and the generation that allowed it to receive may have had to been replaced either by, as you point out, investment or expense. But the quantification of that is a huge imponderable.
And you attempt to say that its reinvestment was uneconomic by comparing Four Corners cost to 2020 Palo Verde prices. Isn't that right?
It is one illustration, yes.
And if PNM had to get replacement resources in that time frame, it would not have been equivalent to the 2020 Palo Verde prices. Isn't that right?
I do not know what PNM, using its significant financial resources, would have been able to obtain. I do recall that El Paso, when it dropped its 7% ownership in Four Corners, did find cheaper. I believe the mix was solar and gas.
Okay. Let's talk about.
I assume PNM was at least as smart as El Paso.
Mr. Hearing Examiner, I would object to Ms. Terwilliger's consistent interruptions of Mr. Sandberg and talking over his answers.
Hearing Examiner, I am not meaning to talk over him. He pauses, and I think he's done. And as soon as I realize he's talking, I have stopped.
Okay, please proceed.
Okay, thank you. So let's talk about your case. You also note the $30 to $300 million in customer savings that is projected in this case, in this application. Isn't that right, Mr. Sandberg?
Could you tell me what you're looking at, please?
Yeah, page 21 of your testimony. You have those block quotes starting at line 6.
Yes, the testimony of Mr. Falgren, it looks like.
And you understand how that $30 to $300 million was calculated? Is that right?
Do I understand? I know that they came up with those numbers. Do I remember the detail of how they arrived at those numbers as we sit here today? No, I do not.
Okay. So you do not understand that that 30 to 300 million was calculated and that it presumes PNM's interest in abandoned and PNM's interest in Four Corners is abandoned and the replacement resource proxies modeled by PNM witness Phillips will replace PNM's Four Corners interest at the end of 2024. You don't understand.
Sorry,
that's
modeled by PNM's.
PNM witness Phillips will replace PNM's Four Corners interest at the end of 2024. You do not understand that's how it was derived, I assume.
I understand that that is what they testified to, but I think it's an irrelevant and misleading attempt to do exactly what Supreme Court says you shouldn't do and go back and try to recreate history post hoc.
So what about the $30 to $300 million calculation is looking at a post hoc analysis?
I'm sorry, is there a question?
Yes, that I asked you. What about that $30 to $3 million in savings is a post hoc analysis?
All of it is.
You understand that it was sorry, go ahead.
Unless I am completely mistaken, these were attempts by PNM witnesses to go back and reconstruct a history which did not happen, which is to say, well, what if we hadn't done this or had done this or hadn't done this long after the decisions in the teens that were actually made.
So are you done?
Yes, ma'am.
Okay, let's go to page 21 of your testimony in that block quote.
Yes, ma'am.
That's paid line 6 to 7. The overall 20-year savings to customer on a net present value basis is estimated to range from 30 million to 300 million. You see that, right?
I see that.
And that customer savings was calculated by assuming PNM's interest is abandoned and the proxy replacement resources modeled by Mr. Phillips are replacement resources for the Four Corners power plant. It's not looking back. You don't, I guess I'm gathering from your testimony, you don't understand how that was calculated. Is that right?
My understanding is this is a calculation of what Mr. Phillips guessed would have happened post 2016 had PNM exited Four Corners, which it did not do. I understand Mr. Phillips to have attempted to say, well, here's what would have happened if we made a different choice.
Mr. Sandberg, are you confusing Mr. Phillips and Mr. Graves' testimony?
I do not know.
Okay. But you used that $30 to $300 million in savings to state that PNM's investment or reinvestment in Four Corners in the 2013 to 2014 timeframe was uneconomic, right?
I'm looking to see that or where that would be.
So So let's go to page 21, line 28 of your testimony. See if you can read that and see if that helps you clarify your testimony.
All right.
So you state there that what PNM's testimony acknowledges is that PNM's investment in Four Corners Power Plant was not economic from the point of reinvestment and has only gotten worse as solar, wind, and storage prices have continued to decline dramatically. You see that?
I do.
So you make that statement by referencing that $30 to $300 million in savings. Is that right?
All right.
You don't know?
I
Objection, he just said all right.
I don't know what all right means, hearing examiner.
Nor do I. Overruled.
the testimony that Mr. Falgren put in, that's quoted at lines 6 to 23, has some extraordinary content. For example, Mr. Phillips's estimation that ranges by an entire order of magnitude from 30 to 300, and then goes on to suggest that there are additional savings. As it is perhaps the best way of explaining this is to point out that these are any of these estimates of what might have happened are completely contrary to what the Supreme Court has said you're supposed to do. It is certainly PNM's position that there could have been savings if we'd done this or that. There could be savings from proceeding as we did, but the record that I'm aware of suggests that economically there were and are more economic ways for PNM to have acquired, as you referred to it a few minutes ago, replacement generation for abandoning Four Corners.
Let me just ask you one more question about this $30 to $300 million savings. I think perhaps you're getting confused with Mr. Graves still, but let me just, you did not do any quantitative analysis of the Mr. Phillips' calculation of the $30 to $300 million in savings. Is that right?
Yes.
You did or you did not?
Your statement is correct that I did not.
Okay. Do you know if battery storage was widely available or cost effective in the 2013 to 2014 timeframe, Mr. Sandberg?
That's a huge question.
Well,
I'm trying to think back when utility scale. I think that would have been at the beginning of the availability of battery storage.
Do you know how much battery storage was deployed in the US grid in that 2013 to 2014 timeframe?
I do not.
Okay. Let's talk about your testimony, the bottom of page 22. You have a question that opens there. Has subsequent facts proven that PNM's Four Corners power plant investment resulted in environmental harm? You see that, right?
I do.
And you attached exhibit CKS 5, and that would be an NEE exhibit 5A, which is APS's annual coal combustion residuals, or CCR, impoundment and landfill inspection report. Is that right?
Yes, ma'am.
And you note future liabilities that are of concern as a result of that report. Is that right?
Yes, ma'am.
Okay, I'd like you to go to PNM Exhibit 26. You only attached portions of the report, and instead I want you to go to PNM Exhibit 26, which are the attachments to New Energy Economy's response to PNM's first set of interrogatories, and you'll that's where you provided us with the full CCR impoundment report. So if you, if
I
you're,
have PNM Exhibit 26 in front of me.
and if you're, are you on a computer? Because if you are, I think you would go to page 65 of that PDF.
I am, and I am scrolling down,
Okay, thank you, sir.
which may take a minute. As I recall, it was a fairly substantial document.
Mr. Hearing Examiner, can you tell me how much time I have left just for reference, please?
Yes, ma'am. You have 27 minutes and 30 seconds.
Thank you.
You're
I
welcome.
could, excuse me. Let's talk about what page numbering we're using. There are internal page numbers in the CCR impoundment report at the center of the bottom of each page, but then there are at the footer of each page, a page count of the exhibit. Are you talking about a particular page as numbered inside the CCR?
I think I have both, so let's just try to navigate through.
Okay.
Okay,
That would be good because they don't even close to line up.
yes, I agree. So I'm looking at page 1 of the CCR impoundment report, which I think is 59 of 213. You see that?
Page 1.
Yes, of the
Okay,
CCR.
I'm sorry. I'd already gone into it a ways. Hang on. Let's get back to the top. Okay, I'm at the Four Corners Power Plant, line dash impoundment, et cetera, report 2020 by APS.
Your
Title
page one of the report which is 1.0 introduction. Are you there?
I'm sorry, I was at the real first page as opposed to page 1. Page 1.0 introduction.
And yes, and you'll see
Okay.
there that it says Arizona Public Service Company, APS, prepared this report to comply with the Environmental Protection Agency's EPA.
I'm sorry, you're reading too fast. Arizona Public Service Company, APS.
I'm sorry, Mr. Lee, I have a sticky note that says slow down and I'm terrible at it. Okay. Arizona Public Service Company, APS, prepared this report to comply with the Environmental Protection Agency's EPA hazardous and solid waste management system disposal of coal combustion residuals from electric utilities final rule. You see that?
I do, ma'am.
And there's some CFRs or code of federal regulations, which are federal regulations that are cited in that introduction. Is that right?
For surface impoundments and CCR landfills, it appears.
Okay. All right, let's walk through in your testimony each of the numbered liabilities. So let's walk through it using this report. So if you go to page 3 of the report, which is 61 of 213, you see the lined ash impoundment at 3.1, I assume. And
That's the top, yes.
Yes, sir. And you see that that was constructed in from 2013 to 2014, do you not?
No, I do not see that. I see it was constructed between 2003 and 2014.
Okay, maybe I misspoke. So 2003 to 2014. Thank you for that clarification. Let's go to the line decant water pond at 3.2. You see that was constructed in 2003, is that right?
That is what it says.
And then number 3.3, the combined wastewater treatment pond. That was constructed in 1978. Is that right?
I see that as well.
Let's go to the next page, if you wouldn't mind. Flip to page 4. That 3.4, the dry fly ash disposal area, that's ongoing since 2007. Is that right?
Well, it says construction of the 3 cells has been ongoing since 2007. That's a lot less precise than the 3.1, 3.2, and 3.3 references, but that is what it says, ongoing since 2007.
Thank you. And then the return water pond that was constructed in 2019 and was placed into service as a CCR on October 20th, 2020, right?
That's what it says.
All right. So just to be clear, for 4 of the 5 issues that you note at pages 23 to 24 of your testimony, they were all constructed prior to 2016. Is that right? Or at least they were ongoing prior to
Yeah,
2016.
I would, with that clarification, I would say, yes, that is what is reported in the 2020 CCR report.
Okay. So before any disallowance was made in the 2016 rate case, 4 of these 5 issues were already, 4 of these 5 matters identified in the CCR report were already things that the EPA was addressing, I should say. Is that right?
I don't know if the EPA was addressing any of these things. All you can tell from the pages you just walked me through is that they were constructed at certain dates.
All right, I appreciate that clarification. So my follow-up question is, none of these issues with the Four Corners power plant go away or cease to be a problem if PNM exits the plant. Is that right?
Given the likelihood of there being significant remediation that costs that will need to be spread among as many parties as possible, I would expect that at the very least, other parties would insist that PNM has an ongoing responsibility to bear part of the cost of the ultimate remediation. The exact way in which they might make that assertion would be up to them.
And you understand that PNM is remaining obligated for its remediation and decommissioning costs associated with the Four Corners power plant, even if this application is approved. Do you understand that?
I believe there is at least an attempt to transfer that responsibility to NTEC, but I believe PNM is the fallback on that.
And do you understand the co-tenancy agreement regarding the Four Corners power plant?
Again, I'm sorry, I heard a first part of a statement, but then either you stopped or I cut out at my end. I'm sorry.
Okay. Do you understand the co-tenancy agreement for the Four Corners power plant?
I would not claim to understand it. I know that I looked at it earlier on, yes.
And under the co-tenancy agreement, that if, let's say, PNM or Intech don't fulfill their obligations in some manners, the other co-tenants would assume those obligations. Is that right?
That is my general recollection of that issue, yes.
All right. So let's talk about the Intech financial condition that you testified to at page 24 of your testimony.
Are we done with exhibit PNM 26? Again, just so I can clear screen.
Yes, sir. Thank you.
No, thank you. I'm sorry, where are we going?
Page 24 of your testimony.
I am there.
Okay. You talk about Intech's financial condition. Is that right?
I talk about the concerns that I have based on present reports about Intech's financial status. Yes, I do.
And let's talk about those reports on Intech's financial status. Are those largely press reports or newspaper reports that you cite to?
Yes, ma'am.
And you don't provide any direct evidence such as Intech's balance sheet or other testimony that would establish its financial status?
As far as I know, Intech is a privately held entity that does not release publicly those sorts of financial data.
Did you research to try to find any specific evidence on Intech's financial status other than press reports?
I know that I attempted to do as broad a search as possible about Intech, using search terms along the lines of Intech, finance, problem, concern, words of that sort into a search. I do not remember everything that may have come back from that search. And that's the extent of my recollection at this point.
And if Intech fails in the sense that it enters into bankruptcy, would the Four Corners power plant fail in the sense that it would shut down if something happened to Intech?
Well, that's a fascinating question. If the linkage you're referring to is the coal supply, that's under NTEC's operations. I guess it would depend on what the receiver in the bankruptcy decided to do about continuing coal supply to Four Corners, and what the receiver's obligation to protect the corpus of the bankruptcy would require her or him to do at the time.
If you think about the co-tenancy agreement that you just testified to, leaving aside the coal supply, would the other co-owners of Four Corners Power Plant be obligated to make up for Intech's obligations if something happened to Intech?
I do not recall that level of detail as we sit here today. I don't think I actually testified to that agreement. You asked me if I knew about the agreement, and I gave you my limited recollection. I have not read it for a long time.
But your understanding is, as a co-tenancy agreement, the other co-tenants are obligated, even if one of the co-tenants somehow doesn't satisfy its obligations. I believe that's what you just testified to a few minutes ago. Is that right?
You posed that earlier question in the context of remediation. Who would cover remediation if NTEC or PNM were unable to do so? And that was the extent of my answer.
Okay, fair enough. Let's talk about emissions at Four Corners. You discussed the Four Corners power plant emissions in your testimony, right? Page 24, same page we were, well, page 24 to 25, really. Is that right?
I think the actual emissions summary is on 25.
All right, thank you, sir. And you state at page 7, line 5, that seasonal operations represents intentions and not facts. Is that right?
At the time of the testimony was prepared, I don't believe there was even a document to look at that might tell you what the seasonal operations were intended to be.
So you did not review the response or the supplement to Sierra Club Interrogatory 5 that was issued on June 28th, 2021, which attached those seasonal operations agreements prior to your testimony being filed on July 12th. Is that right?
I do not recall which Sierra Club data requests I actually reviewed on what dates.
Okay. And I gather you won't, but I'll ask it anyway. Subject to check, you will not agree that the seasonal operations agreements were served on New Energy Economy on June 28th, 2021. Is that right?
You're right. I won't agree to a subject to check.
All right, fair enough. And I assume, though, you now know that the the agreements encompassing seasonal operations have been filed as exhibits to Mr. Fulgren's rebuttal testimony. Is that right?
Yes, ma'am.
And do you have any evidence to dispute the 20 to 25% reduction in emissions for the Four Corners power plant as a result of seasonal operations?
I think that is a misleading and incomplete analysis of the effects of the seasonal operation agreement, because the same agreement provides for the significant extension in practical terms of the life of the plant.
Well, since you didn't answer my specific question, let me just ask you again. Do you have any evidence to dispute the 20 to 25% reduction in emissions that will result from the agreements that encompass seasonal operations?
I think that is an incomplete analysis, but yes, that is what is stated, but I don't think that tells the whole story.
Okay. And you state at page 40 of your testimony, Mr. Sandberg, that Mr. Falgren's sworn testimony stating that denial of PNM's application could result in termination of the seasonal operations agreement is an unsubstantiated scare tactic. Do you see that?
Lines 9 to 13,
Page 40?
lines 9 to 13.
Well, the unsubstantiated scare tactic is specifically on line 11, right?
Ah, yes, ma'am.
All right, great. Did you hear Mr. Falgren testify last week?
Oh. I'm trying to recall which. I'm sorry, I'm not sure that I may have been able to listen to some of that cross exam, but I'm pretty certain I did not hear all of it. I think I was in for part of it.
All right. So do you understand? Well, let me back up. You did review Mr. Falgren's rebuttal, right?
Yes, ma'am.
All right. And you understand that the purchase and sale agreement is a condition subsequent to the agreements encompassing seasonal operations. Is that right?
Condition subsequent.
Well, I'll take you to a site if you would like.
That might be helpful.
All right, we'll do that. Let's see here. Mr. Falgren's rebuttal is PNM Exhibit 6.
Let me. Okay, Falgren rebuttal. All right, I have PNM Exhibit 6 up.
And you'll go to TGF 3, which is an attachment. And that's amendment number 21 to the Four Corners Project Operating Agreement.
Okay, I'm sorry. PGF 2 is a little bit long and I'm trying not to overshoot the end of it. Okay, I see. All right, I'm in TGF 3. Whereabouts in it, please?
Section 3.A, which is page 3.
Oh, once again, I went a little too far. Section 3A, is that section
Yes, sir.
3A on page 3 of the exhibit?
Yes,
Okay. Conditions subsequent to amendments. Okay.
yes. And if you read this, let me know if you can testify that the purchase and sale agreement is a condition subsequent to the agreements encompassing seasonal operations.
Well, 3A says the continued effectiveness of this amendment is subject to the closing of a New Mexico-NTEC PSA on or before December 31, 2024, concluding with, which shall be a condition subsequent to the effectiveness of this amendment.
And what do you understand to that condition subsequent?
It's very hard to get inside the mind of two contracting parties with whom I have no relationship, but I would, well, I guess I don't know what they intended by that long sentence as between the two contracting parties.
Okay. So did you hear Mr. Falgren testify that he did not see a path forward for seasonal operations with PNM's sale of its 13% interest in Four Corners Power Plant to Intech?
I don't believe I heard Mr. Falgren. As I said, I know I did not listen to all of his testimony, his cross-exam. I do not recall a statement such as you just made, which tells me I wasn't on the commission's feed during that portion of his cross.
Okay, thank you, sir. Do you have any evidence to dispute, Mr. Sandberg, Mr. Falgren's testimony about the fact that seasonal operations would not be implemented absent approval of the purchase and sale agreement?
Well, I think it's counterintuitive, and given that the operations as they currently stand, as they would be going forward, have become less and less economic, I would think that all of the owners, PNM, APS, whoever remains in an ownership position, would do their best not to run an uneconomic plant any more than they had to. If in fact seasonal operations is a way, as apparently from this agreement, a way to reduce the uneconomic operations of Four Corners, I don't see why the other owners wouldn't have the same conclusion.
And do you understand that seasonal operations, the reason the agreements were able to be reached, as Mr. Falgren testified, is conditioned or is contingent upon NTAC assuming PNM's 13% interest?
I believe that's what the documents say, yes.
All right. Mr. Heron Examiner, it looks like I'm done sooner than I expected. So I will not use all my 72 minutes. Thank you.
You left 7 minutes and 17 seconds. Thank you. I just say the seconds not to be a geek, but just to let you know I'm paying attention or trying to keep time. So thank you very much, Mr. Williger.
Thank
All right,
you,
up
Mr.
next.
Sam.
That was a thank you to you, Mr. Sandberg, I think, for Mr. Williger. I didn't step on it.
I'm certainly appreciative of the 7 minutes as well.
All right, Ms. Beatles, Western Resource Advocates, you have 15 minutes with Mr. Sandberg.
Well, thank you, Mr. Heron Examiner, but based on Ms. Terwilliger's cross-examination, I have no questions.
Okay. Mr. Harris, Water Utility Authority.
Thank you, Mr. Hearing Examiner. The Water Authority has no questions.
Okay. Ms. Nazi, any redirect for your witness?
No, thank you.
All right, Mr. Sandberg, thank you so much for your testimony. Are you there?
My pleasure, Your Honor.
Okay. Definitely my pleasure. Thank you, sir. You are
Good day.
excused.
I am going to leave the Zoom.
All right, thank you. I think we have Dr. Fisher with us, and it's 10:21. We're probably, Mr. Williger, yes.
Yes, thank you, Hearing Examiner. Mr. Gifford has the privilege of cross-examining Dr. Fisher, so we need to do a switch here. If you can give us a few minutes.
Right, let's take our 15-minute break and I'll try and get some more coffee in me. The first double dose didn't quite do it for me today. But Mr. Marks, I just checked the Dropbox folder, both my Safari. I was going to email you with the Safari and Chrome browser. You sent Dr. Fisher's corrected Sir rebuttal testimony, I think, a few minutes ago, correct?
Yes, this is Mr. Marks. Mr. Medeiros, as we'll get into when we put Mr. Fisher on to introduce his testimony, he found some errors early this morning. I have circulated to the parties. My co-counsel, Mr. Gerhardt, was uploading the corrected version to Dropbox, and I asked him to make sure to put the exhibit tag large on the first page, and I'm not sure if it's up there, but it will be if it's not there.
Well, it just miraculously appeared in the Dropbox folders as we were speaking.
It's a season of miracles.
It is. Short cross-examinations, and but we also need just to remind everyone, we need your final updated exhibit lists as well to correspond to the additions, to try and keep track of what's going on in these Dropbox folders. So please update your exhibit lists to correspond to recent additions like the one that Mr. Gerhardt just added. And thank you, Mr. Gerhardt, out there. All right, so let's take 15 minutes. We'll be back in 15 with our final witness, Dr. Jeremy Fisher. Thank you all. Have a good break.
Mr. Lee, are you there?
Yes, Mr. Marks.
Oh, good. I just switched to my headset. I wanted to make sure the audio was working for the mic and the headphones. Can you hear
Yes,
me
sir.
well?
Yes, sir.
Okay. I think last time I was doing an extended cross, there was some audio problems, so I'm gonna use this.
Okey doke.
Thank you.
You bet. All right.
Mr. Lee, this is Jeremy. While we're at it, I might as well take the opportunity to do a quick mic check as well.
Yes, sir.
Good to go?
Yes, sir.
All right. And please do feel free to interrupt me to tell me to slow down. I am also culpable in that, but I will do the best I can.
All right. Thank you, sir. I can't hear you, Judge.
I haven't said anything yet, Mr. Lee.
I
I wanted to
apologize.
make sure that was 15 minutes.
Yes,
It's
sir.
about 17 minutes. I didn't want to shortchange anybody on their break, but I haven't. So we're back after our mid-morning break on the final day of this evidentiary hearing. Mr. Marks, I see you there. Are you presenting Sierra Club's witness?
Yes, Your Honor.
Would you please present him, please?
Okay. Sierra Club calls Dr. Jeremy Fisher to the stand and to unmute himself. And would ask that the court reporter please swear the witness.
Would you please raise your right hand? You solemnly swear the testimony you're about to give in the matter and opinion should be the truth, the whole truth, nothing but the truth?
Yes, sir.
Thank you, sir.
Dr. Fisher, can you please refer to the document marked as Exhibit SC-1?
Yep. I have that in front of me.
And what is that document?
The document marked SC-1 is my direct testimony filed on July 12th, 2021.
And was that testimony prepared by you or under your direction?
It was.
Are the answers therein true and accurate to the best of your knowledge?
They are.
If I asked you the same questions today under oath, would your answers be the same?
They would.
I move admission of Exhibit SC-1.
Any objection?
No objection.
Sierra Club Exhibit 1 is admitted.
Thank you. And now, Dr. Fisher, can I direct you to the document marked Exhibit SC-2?
I'm there.
Okay. And what is that?
This is the SIR rebuttal testimony that I filed on August 30th, 2021 in the same case.
And was that prepared by you or under your direction?
It was.
Okay. And do you have any corrections to make to that document?
I do, and I apologize for the inconvenience of the last minute nature of these corrections. I have two modestly substantive corrections to make to that testimony with respect to 2 points that I made within it. I can walk you through those.
Can you, and for the convenience of the hearing examiner and parties, could you refer to what's been marked as corrected exhibit SC2?
I'm there.
Okay. And is that the same as exhibit SC2 except for corrections that you have made this morning?
That's correct.
Okay. And could you take us to the first correction?
In a moment, I can walk you through line by line. Would it be more convenient for me to tell you the nature of the two corrections or to walk through line by line first?
Can I direct you to page 6 of 50 and your table 1?
I'm there, yes.
Okay. And does that table show your 2 corrections?
It does.
Okay. And can you tell us what those 2 corrections are and briefly what the reason for them is?
Certainly. So the first correction marked there, which is the red line over consistent future energy requirements, is a removal of one of the corrections or critiques that I made of Mr. Graves' rebuttal testimony on the basis of a clarification that he made within his sir rebuttal. And I agreed with his, at least the nature of his correction in his sir rebuttal, and therefore I'm removing that modification to his assessment.
Okay.
Shall I continue?
Please continue.
The second adjustment is on the next line where it says replacement CT to 160 megawatts.
Sorry, can you start that again? The second
correction is on the next line of table 1 under the category marked replacement CT to 160 megawatts. And the nature of that correction is that in reviewing Mr. Graves' sir rebuttal, I determined that I had neglected to take into account the increased ongoing fixed operations and maintenance requirements of a larger CT, as he concedes might be necessary in that correction. And the larger CT and therefore higher fixed O&M costs that are contingent with that change the value of that correction that I've made and probably change his testimony as well.
What does the acronym CT stand for?
I'm sorry, CT is for combustion turbine.
Okay. And is it true that the other changes in that table are just to flow through those 2 changes you described?
That's correct.
Okay. And then can you point to where your substantive testimony changed?
Yes, so there are a few lines in which those dollar changes are marked throughout the testimony, and I can go through if you'd like on a line by line basis.
I don't think that's necessary.
That's good. Then I would direct you to page 28 of 50 of corrected SC2. And starting on line 9, subsection D, 2021 proposed plan lacks any generation, etc. That entire section through the next page, page 29 of 50, line 6, is stricken.
Okay. And Dr. Fisher, other than striking out that one section and changing the numbers where they appear to correspond to the changes you told us about in table 1, are there any other corrections to your testimony?
No, there are not.
Okay. And with those corrections, is your testimony true and accurate to the best of your knowledge?
Yes, sir.
And if I asked you the same questions today, would your answers be the same?
They would.
Mr. Hearing Examiner, I would move the admission of exhibit SC2 corrected into the record.
Any objection?
No objection.
That's gracious of you, Mr. Gifford. These were substantive corrections that were shown at the last minute. I'm curious, did you see these before they were presented to the rest of us this morning?
We saw them earlier this morning, Your Honor, and recognizing, among other things, that this Sir rebuttal and Sir rebuttal has been happening almost in real time, contemporaneous. We believe it's best to get you the best record and not delay that.
I appreciate that, Mr. Gifford. Ordinarily, substantive corrections like this are not accepted. However, given that Sierra Club presented it to the company beforehand and you had a chance to review it, I don't find it particularly offensive in this regard. So I'm going to make a limited exception, and therefore, hearing no objections to the admission of this corrected exhibit SC-2, corrected exhibit Sierra Club exhibit 2 is admitted.
I thank you, Mr. Medeiros. Thank you, Mr. Gifford. We tender the witness for cross.
Thank you, Mr. Marks. Okay, Mr. Gifford, PNM has requested 115 minutes with Dr. Fisher. Is that correct?
That is correct, and I think we will take perhaps much less than that, Your Honor.
Okay, take the time that you need, sir. Thank you.
Thank you. Good morning, Dr. Fisher.
Good morning.
You've done this enough to know that as the last witness in a hearing, there's the benefit and the burden to both of us is that we stand between this group and a nice late summer afternoon. So let me ask you, start with this question. Have you ever heard the adage, Dr. Fisher, don't make the best the enemy of the good?
Certainly.
And if I understand your testimony here, you believe that there's a better deal out there for Four Corners than the Energy Transition Transition Act application that PNM has brought here. Is that a fair summary?
I believe that, yes, I believe that there is a better deal for both PNM's ratepayers and for the environment than the specific form of the application at this time that PNM has brought forward.
And so, based on that belief, you urge the commission here to deny abandonment. Is that right?
That's right.
And that is, at least in part, based on Sierra Club's belief that directly or indirectly that a PNM exit from Four Corners would mean its permanent shutdown. Is that what you say in your testimony?
I'm sorry, can you restate that? Because
Sure.
I think I misheard something there.
Sure. No, and let me go to your testimony. On page 4, lines 21 through 23, and I'm paraphrasing a bit here, but you say that Sierra Club believes that directly or indirectly, PNM's exit from Four Corners would result in its eventual shutdown. Is that a fair
I'm going to
statement?
apologize. Yeah, I'm going to apologize just on the basis of page numbering, just make sure I'm using the same page numbering as you. I think there's a different numbering in the central header and in the header that's in the top corner. Can we just make sure we're using the same?
Yeah, and I'm going on the central header. If
Okay,
that's
thank you.
for all parties.
And so I'm sorry, can you redirect me back to the line that you're looking at? I'm sorry to run you through this.
Not at all. Not at all. I'm on page 4, lines 21 through 23. And you see there, he says, it was and is Sierra Club's belief that an early PNM exit from Four Corners would mean directly or indirectly the permanent closure of some or all of Four Corners. Do you see that?
That's right. A exit out of Four Corners without any other restrictions on the co-owners or any other contingencies that would otherwise prevent the retirement of Four Corners would probably result in the closure of Four Corners.
And therefore, it follows that what you're urging the commission to do here is deny abandonment of Four Corners.
And that's specifically due to those contingencies that I just referred to a moment ago. That's right.
Understood. And so the denial of Four Corners would mean that PNM remains in Four Corners. Is that right?
For the time being, that's correct. Yes.
And do you believe, let me ask it this way. I was looking in your testimony, and perhaps you could direct me to it. Do you believe that in this application, there is a net public benefit to PNM exiting Four Corners?
So unfortunately, and I don't mean to parse this so finely, but unfortunately, I think it's a fairly vague question, right? So I think that there is a net benefit to PNM exiting Four Corners with no other contingencies in place. However, the form of the abandonment that's been put forward in this particular application includes substantial impacts both on PNM through 2025 and capital costs that PNM will continue to pay. And now also includes a series of amended agreements that will lead to both higher costs for PNM in the short term, as well as a longer term restriction on the abandonment of Four Corners. So all of the elements of the benefits that would be accrued to either the environment, the other entities who are associated with Four Corners, or PNM's customers, I think disappear almost completely with this abandonment. In addition, I would add that the abandonment potentially precludes a substantive disallowance, which might be felt necessary by the commission, and which we encourage. And in conjunction with a disallowance on prior incurred costs, I think there's actually a substantial benefit to ratepayers for staying in Four Corners and then exiting at another time when the entire plant can be retired.
So do you agree or disagree with Mr. Phillips that there would be a ratepayer benefit from PNM's exit as proposed in this ETA application?
So I think Mr. Phillips' assessment missed two important components, right? Mr. Phillips.
Please.
I think at the time that the application was put forward, the two scenarios that he assessed, the continuation of Four Corners through 2031 and the exit of PNM from Four Corners prior, in accordance with this agreement, are not inaccurate, but they are also not complete, right? So one of the very core components that should have been assessed by a more complete assessment, I'm sorry, that was quite circular, by Mr. Phillips, would have been a disallowance on the remaining costs that PNM seeks to securitize in this case. And I think that actually could have negated a substantial portion of the benefit that Mr. Phillips finds through that earlier abandonment. In addition, Mr. Phillips didn't take into account the seasonal operations agreement, which substantively changes PNM's obligations and operations in future years prior to the closure of this deal in 2025.
So do you think by granting this application as filed, ratepayers will benefit or not?
I am not convinced that ratepayers will benefit relative to other alternatives that could be before those ratepayers today. No.
Well, let me go back and state the question one more time. Do you believe that there are benefits to ratepayers from this application as filed? Yes or no?
I do.
Objection to the form of the question. It's not clear whether you're asking for any benefits or net benefits. Could you clarify, Mr. Gifford?
Let me re-ask it one more time, Mr. Marks. Do you believe, Dr. Fisher, that based on this application as filed, there are net benefits to ratepayers? Yes or no?
Can you clarify? I assume you mean PNM's ratepayers?
Correct. PNM's ratepayers.
Thank you. At this stage in time, I am by no means convinced that PNM's ratepayers are better off through this abandonment application than they would be through the continued participation in Four Corners.
So do you have an opinion on whether this application would save ratepayers money?
So Mr. Phillips, for example, provides, I think, a central estimate of, I believe it's $142 million of the benefit of going through the abandonment as filed relative to the continued operations of Four Corners through 2031. If we take everything that he has to say at face value, right, and no other modifications to it, then I don't have a reason to dispute the way that he's otherwise constructed that assessment, but I believe that it's fully incomplete, right? As I stated earlier. So I think the things that it's missing is, for example, $146 million worth of disallowances that would negate that central estimate that Mr. Phillips has put forward. And it also is neglecting the higher costs of operation that PNM will incur through its seasonal operations agreement, i.e. by operating continuously through the otherwise lowest costs parts of the year. Taken together, no, I'm not entirely convinced that the application as filed today has ratepayer benefits to PNM's customers.
Okay, so I think we're getting somewhere. You don't believe then there are ratepayer benefits, is that right?
That's what I stated, yes.
And you don't believe there are benefits from the seasonal operation agreement, right?
We may have to parse that one a little bit more finely, but the seasonal operations agreement isn't in its entirety, I believe, is deeply flawed and problematic for PNM's ratepayers and for the operations of the unit as a whole. Yes.
And operations of the unit as a whole, did you say?
That's correct.
Thank you.
And therefore, if I understand your testimony, you think that this application should be denied kind of at the front end for not showing net public benefits. Yes?
Correct.
And that's because there's a better deal out there, correct?
That's correct.
Now, if this application for abandonment is denied, it's true, is it not, that all other things being equal, PNM would remain in Four Corners until its current projected closure in 2031. Is that correct?
I have no reason to believe that that is true. No.
I understand, but if if we go to the default version of the world, that PNM's exit is not granted here, PNM would remain in Four Corners until its retirement in 2031. Is that right?
To make this supposition that you're putting forward, we would have to believe several relatively absurd truths. One is that PNM would not seek other forms of exit from Four Corners if the other owners continued to want to maintain the plant prior to 2031. And having put forward an assessment, and a fairly convincing assessment, that Four Corners is not in the ratepayers' best interests, I see no reason why PNM would look to stay in the plant through 2031, even after the denial of this particular application and abandonment. In addition, the supposition is that all of the other co-owners would also elect to continue operating Four Corners through 2031. And as I put forward in my direct testimony, and as have events have played out in even the most recent days, I think that there's reason to think that the other co-owners also will be looking for a much earlier exit than 2031. So I think the default that you're laying out does not comport with any reasonable form of reality as I see it.
Well, let's go to the other co-owners and what they've stated publicly. Has Arizona Public Service said anything about its intent to exit Four Corners before 2031?
APS has not said anything about its intent to leave Four Corners prior to 2031 publicly. But as I stated in my testimony, the APS has a very strong incentive not to signal that it has an interest in leaving Four Corners, because it is also involved in a rate case in which it is also looking at a substantive disallowance for the very same reasons that PNM is looking at that disallowance. And any signaling that a movement away from Four Corners at an earlier date would be advantageous to its ratepayers could put APS at similar risk of a commission determining that APS made a faulty decision. And so APS probably will not say that it is reasonable to exit Four Corners until that case is either resolved or close to resolved.
And how about the other owners? Have they said anything?
I believe, and I can go through my testimony, I walked through what each of the other co-owners have said publicly in it. If you'd like to, I can go back to that, but I'd prefer to refer to my testimony if you're going to ask specifics.
No, that's fine.
Okay.
So if I put your recommendation that abandonment be denied, and I pair that up with your other recommendation that the $146 million in undepreciated life extension costs at Four Corners be disallowed, and setting aside the legal issues that might be involved in how that gets done. If those costs, those capital costs are all written down, doesn't Four Corners from a PNM ratepayer perspective start to look like a very attractive asset?
Oh no, on a forward-looking basis, it continues to actually be a fairly disastrous asset for PNM. What we're talking about is and again, the scenarios that PNM is putting forward here and has an opportunity to look at is whether it goes through an abandonment and in doing so locks in these previously incurred costs through its securitization mechanism, or whether those previously incurred costs are denied in accordance with the rejection of this application. That is completely separable from the economics of.
That is completely
separable from the economics of Four Corners on a forward-looking basis. And as Mr. Phillips has put forward in his testimony and in his analysis, Four Corners on a forward-looking basis is not economically attractive to PNM's customers.
Well, if I take out $146 million in capital costs, it on the margin looks more attractive. Is that right?
I would say that I think the way to phrase this one is, even if PNM were to operate Four Corners through 2031, which I think would be imprudent and a mistake for many reasons on a forward-looking basis, ratepayers would be effectively agnostic as to the overall outcome of whether the application is denied or put forward. Now, the fact that I think that right, so that $142 million of benefit put forward by Mr. Phillips is approximately the same level of the $146 million worth of denial that I'm recommending in this case, which would leave ratepayers theoretically agnostic to the direction that's taken by the commission from a net benefit today. But in rejecting the abandonment application, that allows Four Corners to be retired at a much earlier date by all of the co-owners, or PNM to pursue another form of abandonment that does not result in all of these awful things happening to Four Corners and preclusion of voting rights, et cetera, that I think actually is substantively shorter than 2031. So I think that at the end of the day, you'd probably end up with a substantially better outcome for ratepayers through the denial of the application and disallowance.
And so your better transaction, so let me take you back to there's three versions of the world I hear you talking about, Dr. Fisher, two of which you don't like. Version one is that abandonment and securitization is granted here in this ETA application. So do you have that?
Yep.
And version three, we'll get to two next, is that abandonment is denied and PNM stays in Four Corners until its current anticipated closure in 2031. Right?
Yep.
And what you're positing in your testimony is a middle transaction that results in its early closure by all parties coming together at a date. I think in your testimony, you posit 2026, 27. Does that seem fair?
It does. Yes.
And in those three versions of the world, your preferred version requires unanimous consent of all the parties to close the plant early. Is that right?
Ideally, yes. From PNM's perspective, there's also the potential of another exit opportunity sometime between now and 2031 that does not have the same type of restrictions that are put in place in this particular abandonment proceeding.
But for your version of the world to happen, all the parties need to agree that Four Corners needs to be closed in that earlier time frame that you posit. Yes?
For the case in which Four Corners is actually closed prior to 2031, yes, all owners aside from under the agreements as they stood prior to the amendments that have been put forth during the course of this proceeding, all parties but NTEC would have to agree. Yes.
And so that's going to be, those parties are going to be Arizona Public Service.
That's right.
Tucson Electric.
That's right.
SRP.
That's correct.
Salt River Project and PNM.
That's right.
And you believe, if I'm getting your testimony right, that by denying abandonment here, this commission will bring about that agreement to happening. Yes?
I believe that the denial of the application here allows that to happen. I believe that that will happen on its own accord, but I believe that the commission's acceptance of this application absolutely completely precludes any potential that Four Corners could shut down prior to, in this case, 2027 and likely the end of the CSA.
And so if PNM stays in this, if your path comes to pass, Dr. Fisher, PNM then would remain in coal until, let's use 2027 just for example, as the closure date. Is that right?
That's correct. For example, yes.
Right. And if it were the case that there are lower cost resources to serve PNM customers now, as opposed to Four Corners, in that time frame 2024 to 2027, PNM customers would be paying more under your scenario, yes?
During that short window, yes, but again, we're dealing with this somewhat theoretical postulation of this 2027, right? At the moment, I believe that if we look at a 4-year window between the time of a vote to close, say happening in early 2022, after the denial of this application, after the closure of the APS rate case, right, and parties come to that agreement, we could be looking at a 2026 retirement. So we're looking at a year and a half worth of, unfortunately, excess costs, but also a reduction in capital expenditures by all parties in
a reduction.
I'm sorry, but
Also a reduction.
Also a reduction in capital expenditures as that plant nears retirement in those last 2 years.
And have you quantified what those excess expenditures are, Dr. Fisher?
I apologize. I believe I did in my direct testimony where I referred to the costs that PNM would accrue from continued capital, but I don't recall whether I gave it a precise evaluation.
Well, let me ask you this. Do you do a comparison between the lower cost resources that would replace Four Corners and the cost of Four Corners and the effect on PNM ratepayers in that period?
No, I did not conduct that assessment.
If I missed it, I apologize, but I didn't think so. And also in that period, instead of seasonal operation of the units, those units would run all the time. Is that right? In your middle scenario?
So from PNM's perspective, actually, the default, imprudent as it is actually a better operations outcome than the seasonal agreement. As I've both stated in my testimony and as you're sort of implying here, while Four Corners itself may run slightly less during that time period, under the seasonal operations agreement as it stands, PNM will actually have an obligation to operate at an equivalent of 100% capacity factor during 2 full seasons of the year, substantially more than it would today.
And so this transaction that you posit as better, as the best outcome, is that fair? It's the best outcome?
When you say the one that I'm positing, the application is denied, presumably a disallowance follows, and and some form of an agreement to close the plant in a near-term year, leaving adequate time for that closure to happen occurs. Yes, I think that would be the best outcome.
And you believe all those moving parts could come together between those four parties and the decisions that would be required by the New Mexico PRC and the Arizona Corporation Commission. Is that right?
I do.
Okay. So you understand that this application is being brought pursuant to the Energy Transition Act, right?
I understand that that is a component of the application. Yes.
And you understand that well, let me ask you this. Do you believe that the Four Corners costs are in rates right now?
Objection goes beyond his direct.
Overruled.
Can you please restate the question?
Do you believe that the costs for Four Corners are in PNM customers' rates right now?
I think there are some costs for Four Corners that are in customer rates right now. There is plant balance that precedes 2016 that is in rates right now. There are operational costs that are in rates right now.
And do you believe, for instance, that the costs related to the SCRs on Four Corners are in customers' rates?
My understanding, although my recollection here isn't perfect, is I believe that those are currently being recovered at debt service. So rather than the full rate of return being recovered at a lower cost, ultimately.
Understood. And do you believe that was true as of January 1st, 2019?
I'm sorry, I don't recall when that order went into effect.
No, fair enough. I'm not trying to play a quiz show with you. So you you do agree with me that Four Corners is a qualifying facility under the Energy Transition Act. Is that right?
That Four Corners would qualify as a facility for which costs can be securitized if approved by the commission. Is that the nature of your question?
Yeah. Is it a
Yes.
qualifying generating facility under the Energy Transition Act?
I'm sorry, my only hesitation here is that I'm not actually familiar with the term of art that's used within the ETA, sorry, the Energy Transition Act specifically. And my association generally with qualifying facilities is with renewable energy and cogenerators. So subject to check, but that's the correct term. Yes.
That's bringing about a whole nother realm of PTSD for me, Dr. Fisher. Thank you. Now you suggest that PNM's entry into the agreement, the purchase and sale agreement with NTEC, was, as you put it, a rushed transaction. Is that right?
I don't recall having used that terminology, but I would agree with that characterization.
Well, if I go to page 14 of your testimony, and maybe I'm not.
And we're referring to the numbers in the center, Mr. Gifford?
Yes, yes. I'll at page 14, you say the commission could conclude that both the abandonment application and the PSA were unnecessarily rushed to accommodate Avangrid's demands in the merger. Do you see that?
Yep, I do.
And let's, for the moment, assume that's true. Do you see anything in the ETA that says it doesn't apply if there's a rushed transaction?
I'm going to renew my objection. The witness didn't testify about the ETA and has already shown that he doesn't know the statute in detail.
Mr. Gifford?
I'm just asking him if he thinks the ETA has any, in his knowledge, if the ETA has any exceptions to its applicability, Your Honor.
Mr. Medeiros, I'm
Go-
okay
go
with
ahead.
him answering in his knowledge, if he has that
Okay.
knowledge.
You anticipated my ruling. Thank you, Mr. Marks.
I'm afraid I actually don't have enough of a detailed read on the ETA at this time to be able to answer that question satisfactorily. Sorry.
Dr. Fisher, did you hear Mr. Falgren's testimony?
Unfortunately, I did not know.
Okay. Are you aware that Mr. Falgren testified that he was you are aware, are you not, that Mr. Falgren was the principal negotiator of the PSA with NTEC?
I would accept that. I apologize that when you say the primary negotiator, I don't know if that means during the process or the ultimate signatory too, but I'm willing to accept that.
Okay.
During the process or the ultimate.
Sorry, or the ultimate signatory to the agreement. But I am willing to accept that.
And are you aware of Mr. Falgren's testimony that he learned of the proposed merger with Avangrid nearly contemporaneously with its public announcement?
I do not have that specific recollection, no.
Okay. And the deal with NTEC was announced 8 days after the Avangrid merger was announced. Does that sound right to you, Dr. Fisher?
I believe I stated that in my testimony, yes.
And Mr. Falgren, let's say he knew 2 days before that. Just let's suppose that. Will you do that for me?
I'm sorry, what are we supposing that Mr. Falgren knew or did not know?
That Mr. Falgren learned about the Avangrid merger 2 days before it became public. I think he said a few days may have been his testimony. Will you accept that for purposes of these questions?
I really have no specific knowledge of. If you can point me to his written testimony about when he had that knowledge, I'd be happy to take a look at it, but I'm sorry, I feel like we're working on a hypothetical that I don't have a basis for.
Well, all I'm asking you to do is accept the premise of the hypothetical that Mr. Falgren learned of the Avangrid merger only days before it was publicly announced.
Accepting that it's a hypothetical in my mind, yes.
That's all I'm asking. So you don't believe that Mr. Falgren negotiated the NTEC deal in under a week, do you?
I doubt it, no.
Okay.
But I'm sorry. Let me just continue that answer for just one. But recognizing that I haven't seen his testimony to that extent, I would be quite surprised if Mr. Falgren hadn't been aware of those moving parts and pieces prior to that date. But accepting that premise, no, obviously 8 days would not be sufficient time to negotiate such a deal.
So you would agree, well, you would agree with me that the ETA allows securitization of costs that are necessary to maintain the safe and reliable operation of the generating facility?
Objection. The witness doesn't have a foundation with the ETA.
Overruled.
Was your question whether the ETA authorized for safe and reliable? I'm sorry. Better
The
for you to
ETA
restate.
Yeah. Do you understand that the ETA allows for the securitization of costs that are necessary to maintain the safe and reliable operation of the qualifying generating facility?
I'm sorry, this actually feels like it would be something where I'd need to see the language of the ETA, because that
Okay.
very specific language, even in other
Sure.
states, is quite important for the determination of what
All right,
is allowed.
Okay, could I ask you to turn to PNM Exhibit 20?
Yes, I'm there.
And if you go to, and that's the Energy Transition Act, correct, Dr. Fisher?
That is how it is labeled. Yes.
And could you go to 6218-2H2D?
I am there.
And could you just read that for yourself?
Yes,
And
I'm there.
And is your understanding of that provision that that costs that are necessary to maintain the safe and reliable operation of the qualifying generating facility prior to the facility's abandonment, those are recoverable under the Energy Transition Act? Is that how you would understand that provision?
For costs that are allowed into the energy transition cost or financing charge by the commission, those costs can include or should include costs that are necessary to comply with safe and reliable operation.
And those costs, in your understanding, those costs can be securitized, or at least that's what this purports to say.
That's right. I do want to add the piece here that said the qualifying generation facility prior to the facility's abandonment. So that we're of an understanding that it's costs that would be costs that were incurred prior to its abandonment time period.
Right. And do you understand that those costs, if abandonment were granted and securitization happened, those costs would be recovered pursuant to this provision? Would that be your understanding?
That's right. And actually, that's one of my concerns with the commission authorizing abandonment, in that in doing so, it removes many of the costs that are currently contested as having been reasonable and prudent in the first place, and puts them into a category outside of the commission's jurisdiction and into this energy transition cost instead.
Well, let's go to the prudence issues that you talk about. You recommend full disallowance of the costs being sought to be securitized here?
My
or partial?
I believe it amounts to a partial. I don't believe I'm including costs that were incurred prior to mid 2016.
That's right.
Right.
So there, in my understanding of your testimony, there are three tranches of costs at issue here. There are the pre-2016 costs that you believe are properly recoverable. Then let's call the second tranche the SCR costs. I think, can we understand that as a?
And that second tranche would include both SCR and other capital investments that were made during that same time period. Yes.
Understood.
But-
And
Could
then
let him
there's-
fi- I was just going to ask Mr. Gifford, you let him finish, and then also if you could make your questions more clearly questions. It sounds like a discussion, but I think the hearing examiner would appreciate a record that had questions.
Only for you, Mr. Marks, of course. So, and then there are the costs, the third tranche of costs, if I'm right and understand your testimony, are those costs related to the ongoing operation and maintenance of the plant going forward. Is that a fair characterization?
That third tranche of costs are recently spent and unspent capital costs at Four Corners.
Okay, perfect. Thank you. And you recommend disallowance of those last two categories. Is that a fair summary?
No, my specific recommendation is that those be rejected within this application and put forward as part of a prudence review.
Okay, so you're not making a prudence recommendation here then, are you?
Can you clarify what you mean by here?
In this case, are you urging the commission to find those costs imprudent? Yes or no?
Which costs? Sorry.
The costs that we just spoke of, the non-pre-2016 costs.
In the three categories of costs that you listed, the pre-2016 costs, we've agreed that I am not making a prudence recommendation on those. There are the costs that were incurred in conjunction with the SCR that were incurred from mid-2016 through the next couple of years in accordance, which amounts to $146 million in undepreciated plant balance. And I am making a prudence recommendation there that those be disallowed in full. And then the third tranche of costs, $73 million, which are recently spent and as of yet unspent through 2025, I recommend that the commission conduct a prudence assessment on those costs. I am not recommending a disallowance of those costs at this time. I'm just recommending that they are ejected from this application.
Okay, and that's where you and Mr. Graves, for lack of a better term, you take let me start over, Dr. Fisher. You take issue with Mr. Graves' testimony, both his ex-ante prudence testimony and his ex-post prudence testimony, as the hearing examiner has called it. Is that correct?
That's correct.
And you, in fact, argue in your testimony that those costs that you say are imprudent should be immediately removed from rates. Is that correct?
That's correct.
Now, you've testified in prudence proceedings before, is that right?
I have, yes.
And in fact, in your surrebuttal testimony, you mentioned those cases, or a few of those cases at least. Is that right?
A subset, yes.
And you talk about a case in Oregon, is that right?
I do.
And in that case, it concerned emissions control investments, is that right?
That's right.
And the outcome of that case, and we're talking at page 7 of your Sir rebuttal testimony, the Oregon PUC disallowed 10% of the emission control investments there. Is that right?
I believe so, yes.
And you also...
I'm sorry, can I just clarify and correct? The commission disallowed 10% of all emissions controls that were at issue in that case. So not just the emissions controls that were associated with one unit, but emissions controls across a cohort of plants.
But 10%, not all of the emission controls, is that right?
That's correct.
And you also cite a Washington decision on pages 8 and 9. There, the UTC did not take a full disallowance of the investments at issue, did it?
I'm sorry, just a moment, please. The UTC did not take a full disallowance on all of those costs, but the reasons that it gave are unique to that case and not similar to those that are presented here.
And on the Indiana decision, they disallowed, if my math is right, 10 million out of a $511 million capital investment. Is that your recollection?
So that's the part that I testify to. Actually, there was an additional component of that order as well, in which the commission identified that any forward-looking, any costs for carbon costs that might otherwise be incurred at a future time would be held by the company alone. And I believe it stated as well that the capital investment that was at issue in that case would also be held in a separate account by the, just a moment, please, would also be held in a separate account by that utility. And if it incurred the costs, but at a later time determined that the plant was no longer economic to continue operating, the utility would actually incur those costs on its shareholders' backs.
No longer.
I'm sorry. Can you back up to the beginning of that sentence, please?
Would also be held in a separate account by that utility, and if it incurred the costs, but at a later time determined that the plant was no longer
useful for customers, that the costs in that account would be incurred by shareholders, not ratepayers.
Dr. Fisher, is no longer useful for customers the same as not economic? Because you used economic the first time. Okay, thank you.
Yes.
The immediate disallowance, though, Dr. Fisher, was 10 million out of 511 million, correct?
Yes, and the commission identified specifically that that portion of the disallowance was actually managerial in nature. It was due to the bad performance of the utility in that proceeding.
Understood. Now, here, you would agree with me that Four Corners has been serving PNM's customers since that 2013 decision to remain in Four Corners. Is that right?
Yes.
And customers have derived benefit from that plant.
They have derived benefit from that plant, but not the same benefit relative to the costs that they would have otherwise paid for an alternative resource.
Sure, sure. And that's the point and the analytic undertaking that Mr. Graves does. Yes?
That's what Mr. Grave portends that he does. I don't agree that he successfully does so.
I understand that all too well, Dr. Fisher. You don't do an analysis of what the next best resource would have been, do you?
I do not. And as I testified, I believe that a more thorough assessment of what that next best resource or resources would have been is properly conducted through a system model, such as that used by PNM either at the time, strategist, I believe at the time, or today in Compass.
But you don't do that here in your testimony, is that right?
No, I did not have the opportunity to also run a system model in addition to everything else.
Right. But would you agree with me that the measure of disallowance, if any, should be between the resource that served customers and the next best resource that should have served customers?
So I believe, as I talk about in my testimony, the commission has a number of different routes that it can take here, right? I think Mr. Graves testifies, and I believe I agree, that in the ideal circumstance, one could do we'll, for the sake of the purposes here, call it the ex ante assessment using a full model of what the company would have known at the time that it made its decision, and then how that future would have played out relative to the future available to the company today, and then look at the damages that have actually been incurred and will be incurred by the company on ratepayers and try to make ratepayers whole. That would be ideal, but the commission also has an opportunity to disallow costs that it believes shouldn't be in rates. And for lack of a better assessment that otherwise tells us what that would appropriately be, and I do not believe that Mr. Graves' testimony gets anywhere close to that correct form of assessment, I think that the commission's best option at this point is to start with the full cost of that disallowance, but it could elect to make that a smaller number.
But you say on page 51 of your testimony that it's the net detriment to ratepayers. Isn't that the analytic undertaking?
Can you point me to that line, please?
Yeah, let me get there.
Oh, I'm sorry. I found that line. Looks like it's line 26.
Yes. So you're asserting that there was a net detriment to ratepayers rather than a benefit to staying in Four Corners?
Correct.
And the net detriment is the increment that should be the goal to ascertain here?
The net detriment sorry, just a moment. The specific statement here is that at the time the decision was made, it would have been apparent to the company, had a proper analysis been conducted, that staying in Four Corners was a net detriment. The amount of a disallowance, as Mr. Graves attempts to do, and I think we agree in principle, would be closer to an ex ante modeling assessment. And I described that, I believe, in my rebuttal, or my rebuttal, that the proper form of that assessment is to do a modeling assessment starting at the time that that decision was made, using real costs until the present time, and then going forward from there on the best possible projection that we can do at this time.
Thank you, Dr. Fisher. Guess one final set of questions. you don't really testify, and I think this is what Mr. Marks was getting at, a lot about the way the Energy Transition Act applies here in your testimony, do you?
No,
But you're familiar with the Energy Transition Act from the San Juan case where you testified, right?
in a rough form, yes.
And in the San Juan case, you did support abandonment?
That's correct.
In your familiarity with, or in your knowledge, does the Energy Transition Act contain a prudence test before securitization can be accomplished?
I'm sorry, I don't have specific enough familiarity with the text of the ETA to identify specifically where the commission's incursion in those costs, in that determination would take place. And I think that's material.
So would it be fair to say you don't know whether or not the Energy Transition Act contains such a provision?
Would you bear with me for a moment? So my understanding of the Energy Transition Act is that the commission has the jurisdiction to either accept or reject a financing order application. And in accepting it, it may in fact accept costs that may be already considered in rates, or that are applicable to the financing application. In rejecting it, it preserves the option of being able to make a prudence disallowance.
You've testified, Dr. Fisher, in a number of cases concerning coal plants. Is that right?
That's correct, yes.
How have you testified in any other cases that a coal plant should be kept open?
So I've testified in a number of cases that have looked at an entire utilities portfolio. And the point of my testimony and my assessment has always been to assess if a company is making a wrong decision. And then I testify on that specific wrong decision. And in many of those cases, it has been with respect to fossil fueled plants. But in many of those cases as well, there are plants that there are decisions happening at to which I don't testify. So for example, Pacificor is one that I mentioned, where there are cases, both IRPs and CPCNs, where the company is having an application both for one plant and a separate plant. And in those cases, if I don't think that there's a case to be made on one of the plants that's at issue, I don't testify on that particular plant. And I don't think that's unusual. So I've never specifically testified in support of a retrofit, but I've also not testified where it was not appropriate to discuss an error that had been made by the utility.
Thank you, Dr. Fisher. I have no further questions.
Thank you.
Thank you, Mr. Gifford. Ms. Beatles?
Based on Mr. Gifford's cross-examination, I have no questions. Thank you.
Mr. Harris?
Mr. Hearing Examiner, I have no questions. Thank you.
Dr. Fisher, thank you for your testimony in this case and testifying today as well. Just very briefly wanted to discuss with you a little bit about Mr. Graves. Were you present or did you hear his examination?
I did not.
All right, I think I'll just leave it there then. Mr. Marks, redirect.
Maybe just a few questions.
Sure.
Okay. Mr. Gifford asked you about what he called 3 versions or 3 scenarios, but he called them versions. And just version 1 was approval was granted. Version 2 was approval was denied in this case, but it was a subsequent PNM exit in 2026 or 2027. And version 3 was abandonment was denied and PNM wound up staying through 2031. Is that your recollection of his versions?
Yes.
Okay. And just to be clear, is it your testimony that version 1 and version 3 are roughly the same economic impact to PNM's customers?
No. Version 2, in which PNM has an opportunity to remove itself from Four Corners, avoid further costs, and in which this application is denied, and in which it doesn't enter the seasonal operations agreement, and in which costs are disallowed, has substantial value relative to option 3.
Okay, that's 2. What about 1 versus 3? His worst case scenario, that the commission denies abandonment and PNM finds it stuck through 2031.
Presuming that the commission follows through with my assessment as well, that there should be a prudence disallowance of approximately $146 million, ratepayers would be, according to Mr. Phillips' estimate, approximately agnostic between that worst case scenario and the abandonment application.
Okay. And then, as you said, but the denial opens the door to the second scenario, which is beneficial.
Correct.
Okay. And then Mr. Gifford asked you about all the things that would have to happen, all the co-owners having to agree. Is there anything that you're aware of that would indicate that the co-owners other than APS, in other words, Tucson Electric and SRP, are more aligned with PNM on desiring an early closure?
I believe I put in my direct testimony some public statements that said that those utilities were interested in examining earlier closure as well. And I believe that there was also a back and forth between, I believe it was Mr. Falgren and APS, discussing the eagerness of other partners to potentially exit as well, that I included as a exhibit to my testimony, if I'm not mistaken.
Okay. And would you agree that these decisions are not wholly these utilities to make on their own, and that at least aside from Salt River Project, the utilities are subject to their respective state utility commissions?
Absolutely. And in APS's case, and presumably this would be applicable to TEP as well, the commission has already directed APS to examine an earlier exit out of Four Corners in its next IRP. And so both in recognition that the prior costs that were incurred, the hearing examiner, in that case, it's a recommended order. Both in that case, there's a recognition that the costs that have already been incurred were likely imprudent, and a very serious recognition that the forward-looking costs for Four Corners could also be considered imprudent if APS and presumably also TEP do not conduct that type of analysis. And so like PNM, the regulators in that case have an opportunity to help direct the future resource options of those utilities.
Let's see. Mr. Gifford asked you about Mr. Falgren's testimony, and I cannot recall what Mr. Falgren said about when he learned of the merger. Is it whether or not Mr. Falgren knew the specifics of an Avangrid merger? Is it your testimony based on the evidence you reviewed that Mr. Falgren appeared to have an unusual urgency to finding and closing a deal that turned into the NTEC PSA?
Oh, without a doubt. I believe I testified to and included several emails from Mr. Falgren encouraging NTEC to move quite quickly. And in some cases also, I believe his discussions with, I believe it may have been APS, where APS responds to his call for urgency to come to some decision quite shortly.
Okay. Hey. Thank you. Thank you, Mr. Fisher. Thank you, Mr. Medeiros, for allowing me redirect.
Of course. Thank you, Mr. Marks. Dr. Fisher, truly appreciate your testimony. Thank you. It's good to see you again.
Thank you for having me.
You're excused. Thank you. All right, we've concluded the evidentiary phase of this hearing. I want to take only about a 15-minute break and then come back for post hearing issues regarding first our issue framing discussion and then setting a briefing schedule and then concluding the hearing. So let's take 15 minutes. I'll see you at around 12:15. Thank you.
Got chapstick quickly. Can you bring it? I'm ready, Judge.
Thank you, sir. Thank you, Mr. Lee. Okay, we're back from our final break. This hearing in case number 21-00017 UT. And I've proposed that we hold an issue framing discussion. Let me preface that this will not be, it's not designed to be an oral argument. It's intended to be a collaborative effort to do our best to refine and define the issues to be addressed in post-hearing briefing. Let me preface this also by saying that it's not intended, this discussion or my discussion of the issues with you, to be an exhaustive list of all the issues to be addressed in the proceeding. If you see a framing of issues in my briefing order, please bear in mind that it's not intended as an exhaustive list of the issues to be briefed. Obviously, the parties need to brief all the issues that they believe relevant and significant and important to their positions in this proceeding, which is multifaceted and obviously contains many complicated issues and concerns. What I'm going to do is go issue by issue. I have about, oh gosh, I've got about 10 or 11 potentially issues to discuss with you. I'm going to start the discussion by addressing the issue and then asking for the applicant's input, PNM's input, and then in no particular order, politely requesting the opportunity to speak on the issue, so that identifying yourself and not stepping over each other to the extent possible, so that we get a clean record of the discussion, and that the court reporter not be unduly taxed in this discussion. So let's try and keep that in mind as we move forward with this discussion. So I guess I'll start with what I consider to be, or at least I've written here, as the elephant in the room. And I refer you back to my discussion with Laura Sanchez and of her rebuttal testimony on page 21, and my discussion with her regarding the recommended decision on the financing order in case 19-00018 UT, that where the hearing examiners observed that the ETA preserves PNM's ability to recover certain costs that the commission has or appears to have previously determined to have been prudently incurred. So in 16276, the commission deferred the issue of prudence of the undepreciated investments, the SCRs, and additional capital investments in the FCPP in Four Corners between July 1, 2016 and December 31, 2018. Question goes to whether the commission implicitly reserved the issue such that the subject investments are amenable to or subject to a prudence review that supersedes, is not subject to, or is somehow not necessarily covered by ETA section 62-18-2H2C, which defines energy transition costs to include, among other things, undepreciated investments as of the date of the abandonment on the qualifying utilities books and records in a qualifying generating facility that were either being recovered in rates as of January 1, 2019, or, and I won't quote the rest of it because that's the operative part of concern. So I guess I'm interested in finding out, was the commission's implicit reservation sufficient to
Implicit
implicit, yes, thank you.
resolution.
Reservation or deferral sufficient to, for want of a better term, elide, E-L-I-D-E, the ETA in this limited instance. And bear in mind in this discussion too, my discussion with Attorney General Witness Crane, in light of the Intervening Energy Transition Act, would it have made any difference if the commission had provided upfront notice to the utility, to shareholders, to potential future bondholders, the investment community, or stakeholders generally, of the ability or potential for making the, if there was a determination of imprudence in the subsequent proceeding with regard to the disallowed investments, whether the commission said in the 16276 revised final order that the disallowance or that the investments already put in rates as of January 1, 2019. They were actually in rates in 2018, if I understand the evidence, that it was subject to refund or clawback, that whole discussion. And in that regard, I think Ms. Crane touched on something that was important potentially with regard to notice and due process rights. Because she says in relation to PNM versus the public regulator, PRC, at paragraph 60 to 65, where there's that discussion of the decommissioning investment issue, that Ms. Crane observed that if the utility is given upfront notice of the intent to do a refund or clawback amount of amounts already recovered in rates. So if there had been a more express qualification or any express qualification, as opposed to an unqualified placement of the investments at the reduced debt return, would that have made a difference in this regard, or with regard to giving notice that this species of investment, this category of investments, may be treated differently in terms of the Energy Transition Act? So I rambled a bit, but I tried to put out a lot of information there around this issue to start the discussion of how the issue could be framed for briefing. Mr. Gifford, any thoughts on this?
Well, I think you framed it well, Your Honor, and I think, as you've seen and we've all seen, this is one of the core threshold issues that is disputed here as a matter of legal construction. And at this stage of the game, for our part, we're most interested in knowing what you're most interested in, Your Honor, because you get to make the decision here. But I think you framed the question, and that we've all, in our respective ways with our respective views, been trying to address that issue, which is what is or was, if anything, the legal effect of both that the Energy Transition Act and of that commission determination out of the 2016 rate case, and how they interrelate today, right? And that's what I understand you want briefing on, and where many of us have already done our best to marshal evidence, and at this stage, I think our next step is to marshal legal argument to you.
Right, and bear in mind, was what the commission did, and was it an implicit reservation? Could there have been something done more that might have changed what the legislature, the effect of the ETA, the section that I just, and other applicable sections, but most particularly, that's the one that PNM has focused on most specifically from the beginning of this proceeding. I think, is that correct? The one that I just said, 6218 2H 2C?
That is correct, Your Honor.
Whether a more a qualified reservation or deferral might have made a difference. Again, looking at what Ms. Crane alluded to, and there I think the testimony was on day 4, the transcript, page 883. She talks about something that I want to have the parties also address, and Mr. Elliott for the Attorney General on pages 882 and 893 through 94 of the transcript, where, and I'll ask you, Mr. Elliott, at this point to pay particular attention to this. She mentioned a WUTC proceeding that she apparently was involved in, that involved some sort of prudency review. It may have been a Pacific Court proceeding. I'd be interested in seeing that decision and others like it, to see what a proper withholding or deferral of a prudence review for a subsequent proceeding, and the language that regulatory commissions use, utility commissions use, in saying we're going to defer whatever the language may be. But it's clear in the transcript what I'm talking about, and what I asked Ms. Crane about, and she, in her experience, provided in terms of the language that goes to that upfront notice or notice issue that I think may be important, may not be important. I don't know, but it's something certainly that the Supreme Court found important in that case. And I didn't give you a citation for that case. It's the Supreme Court decision, I believe it's from 2020, regarding the 2015 rate case. shaking your head, Mrs. Nazi. You want to add something at this point?
It's 2019, and I can give you the site is 444. I'll get it. What's
Yeah,
it?
it's 2019-NMSC-012. 444 E3rd 460. And the paragraphs I'm talking about were the ones that you probably didn't like regarding paragraph 60 through 65, where the Supreme Court holds that it was a violation of PNM's right to due process of law to deny recovery for all future nuclear decommissioning costs. Correct?
Yes, Your Honor.
Just have a lot of cases. The 2020 case was the one I'll be talking about. One 2020 Supreme Court case I'll be addressing in the next issue, and that's State ex rel. Egal versus the Commission. But on this issue, so Mr. Elliott and others, first off, just generally, if there probably aren't, because it's sort of an odd situation, but this may be a one-off unprecedented situation. But are there any other analogous circumstances out there in reported cases where there was a deferral like this and then a change in law that impacted? And this may go to the next issue we'll talk about. And more specifically, Mr. Elliott, in your briefing, I'll be looking for the citation to that WTC case that Ms. Crane talked about on pages 893 through 94 of the transcript, and previously alluded to on page 882. You're nodding yes.
Just taking myself off mute. Yes.
Thank you, sir. Okay, anything further to add from any of the interveners? Ms. Beatles.
I wonder why you say in 16276 that it was an implicit reservation, because I see it as express. If you look at the revised order, it says that the commission is justified in deferring this finding until the next rate filing in order to permit participation of all parties without any constraints and a more full opportunity to consider remedy. So yeah. I see it as an express reservation of authority. So maybe that is something that, we'll address in our briefing.
No, I think that's a good point. That's why this discussion is fruitful, because what I'm talking about is the implicit issue on notice, the implicit issue going to what happens if we determine, because and again, this goes to that unqualified placement of the so-called, according to paragraph 8 of the modified revised stipulation. Is it called disallowed investments? I believe it was just CSR in the revised stipulation. And then based on our determination in the commission's, well, anyway, I believe it's a disallowed investments. Got the certification, the stipulation. I had that paragraph up because we'll discuss it a little bit later. But it's the unqualified placement of the disputed investments, if you will, in rates at a particular rate of return at the cost of debt, right? That's an implicit in, if you're deferring a prudency review, you're implicitly saying something could happen that the utility might not like, that might be unpleasant, like a refund or disgorgement or a clawback But the commission didn't say that. The commission said what it said there, and I'm not going to repeat it, but because I don't want to misattribute anything at this point. Is that Ms. Beatles?
Yes, and I don't want to represent that WRA will be taking one position or the other on whether costs should be disallowed now or later, but we do protect and will advocate for commission authority to make such a determination. But as you know, ultimately our expert said that approval with certain conditions of the abandonment is in the public interest, and he explains that, and we explain that in this hearing, but we just want to protect and preserve commission authority despite the claims about the ETA.
Well, that goes to the second issue, which is quite directly, did the Energy Transition Act potentially modify the commission's rate-making authority to determine the prudence and reasonableness of recoverable costs? In the isolated example of where the commission either made a judgment or appears to have potentially, because of the effect of what the legislature determined for the commission, and saying that if it's in rates, according to the provision above that I quoted to you, that PNM is hinging its hopes on in part, that basically is the commission constitutionally obligated pursuant to the New Mexico Constitution, Article 11, Section 2, stating in pertinent part, and as amended in 2020, that the commission, quote, shall have responsibility for regulating public utilities as provided by law. So is the commission therefore constitutionally obligated to authorize the securitization of costs on which a determination of prudence was expressly deferred or reserved, but subsequently not determined prior to the passage of the ETA? And again, that's why I mentioned state XREL EGOLF or EGOLF versus the commission 2020 NMSC 18, that's 2020-NMSC-018, paragraphs 17 and 33. Did I anticipate that, Ms. Beatles?
Yes, and I would add that there's a question as to whether the commission may attach a condition to approval of either the abandonment or financing order that makes recovery subject to reconciliation with the outcome of a later prudence review. And
well,
I think that's a subtopic of what you just raised.
That's actually the next issue after. You're following along in sequence where I'm going, because that's the third issue. But before I go to that issue, I see hands up. I need to ask first, consistent with the order, the applicant, Mr. Gifford.
No, I agree that's an issue. I'm happy to give you our answer, but I fear it will not receive unanimous consent here today, Your Honor.
I highly doubt it. Ms. Nazi?
I think that I think that there's relevant case law that would confirm what Ms. Beatles just raised, and including our Constitution, which I believe forbids the impairing of the obligation of contracts, and that's Article 2, Section 19. So if we were consistent with that, and I think relevant case law that WRA has already cited in this docket in responses to your other queries, other filings, that the ETA can apply or does apply. And it may, I mean, New Energy Economy's position is it only applies post the prudence, we're hoping, disallowance. And then, yes, everything could be securitized if abandonment is approved. So I just wanted to raise that in this context.
Thank you, Ms. Nanazi. And that raises another question that I want to address later on, that I have listed here. That is something that Ms. Beatles raised in one of her cross-examinations regarding a potential waiver. I don't know if that's still the issue, but she talked about a waiver by PNM consenting to the rate treatment, if you will. That's a shorthand. But that's something that Ms. Beatles raised in one of her cross-examinations this week. And that may go to that, whether PNM somehow is bound by its commitment to allow a prudence review that would supersede or not affect that, at least that particular special investment. This now goes to the third issue, which some of you have already anticipated, which is whether the Energy Transition Act allows or provides any room for the Commission to perform a prudence review of the Four Corners power plant capital investments that PNM is requesting to recover through securitization financing. And here I want you to look at the recommended decision on financing order that at the pages I discussed, but I want you to amplify and expand on the discussion, specifically addressing the issue by the four temporal, TEMPORAL, categories or tranches that Mr. Gifford was discussing with Dr. Fisher. Presumably the first two tranches, and here where I'm looking at the investments are those set out in PNM witness Thomas Baker's supplemental testimony on page 2, PNM table TSB-1, 3-15-21 supplemental. Discuss each tranche. First, presumably the first two tranches go together since they're potentially covered by ETA section 62-18-2H2C, which of course defines energy transition costs to include those undepreciated investments on the utilities, either being recovered in rates or otherwise as of January 1, 2019. So, and then we have the subsequent tranches. Mr. Gifford talked about some of that, and Dr. Fisher deals with some of that apparently in his testimony regarding the two subsequent tranches. I'm not going to belabor it here, but you know what I'm talking about. Regarding safe and reliable service before the abandonment is actually effected. So here, again, it's a question of whether, related to the issue above, whether the legislature changed in this specific instance, regarding these two, regarding San Juan and now Four Corners, the commission changed, but in particular Four Corners. Obviously, the commission, the legislature, altered the rate-making authority of the commission such that the commission is bound to apply the ETA without the benefit of being able to do a prudence review of investments or costs placed in rates. I'll take the party's observations on this. Do you have anything, Mr. Gifford, for the applicant? No.
No, and I think, again, Your Honor, you're framing the issues that we anticipated. I assume from your characterization of this as a discussion, you don't want us to treat this as a preseason for oral argument, so I will not indulge that.
Right. And Mr. Gifford, I want to make sure I have the issues right that I'm asking. So thank you for your indulgence on that if this seems like it's too obvious. I just want to I want to tread very carefully in this case. There are a lot of sensitivities going in lots of different directions in this case, and I want to tread very carefully as I try to, but that's why I'm going through this exercise, and this perhaps painful exercise that I ordinarily wouldn't engage in. But I think the special circumstances dictate special treatment. Ms. Beatles, you had your hand up at one point.
Yes, I'm probably showing too many of my cards, but I don't mind doing that. I was raised in public government. I'm transparent. So ultimately, the Public Utility Act and the ETA must be read in harmony. And I think—
Sorry, can you start that statement again?
I'm sorry, Mr. Lee. Ultimately, the Public Utility Act and the ETA must be read in harmony. So I think the challenge, the tricky part is how we get there. And I think that we need to look at whether the commission must disallow any imprudent amounts now, or whether disallowance or litigation of those amounts can be deferred again. And then—
Well, and then here, remember what Ms. Crane said. Once those costs are securitized, it's very hard to unwind it. And I'm paraphrasing, but it's around that same place in the transcript. I think that's a point we all need to consider. I think she may have a point there. And again, remember, this isn't just done. I remember my discussion, look carefully at my discussion with the witnesses around bypassability on this. That might inform that concern and how to address the issue. But it's a good point. It's actually, yeah, but it's a point. Now, I'm not going to lay any cards on the table because, quite frankly, I have none to lay on the table at this time. I have not decided the case, obviously. Mr. Gerhardt.
Thank you, Mr. Medeiros. So just 2 points real quickly. So first, at the risk of not directly answering your questions, I want to convey that these first 3 issues you've posed, these first 3 questions, only arise if abandonment is granted. I just wanted to clarify that I think the legal framework here is that the applicant has to first meet its burden under the Public Utility Act of showing a net benefit, because the ETA says that abandonment approval is a precondition of eligibility for a financing order. So I just wanted to note that from our perspective, there's that threshold issue of whether the abandonment standard has been met.
I'll just note that, yeah, that's issue 5. I have some very apt students here.
Sorry.
Yeah, that's because, no, but that's, at one point, I'll get to it, but let me just say, I'll touch on it. It's issue 5, and it goes to partly my discussion with Ms. Sanchez about what the PNM expects the commission to do and what it thinks that the Supreme Court ordered the commission to do in applying the ETA, going back to the e-golf decision. So, yeah.
Okay. If I could just, oh, sure. The second point is, I do want to touch on this notion that the ETA might permit the commission to allow the costs that were at issue in the 2016 rate case to be included in the financing order here, and then in a future rate case, revisit and potentially claw back those costs. Sierra Club does not believe that that's permissible. I think, as Your Honor hinted at, that the non-bypassability and finality specified by the ETA does not permit that. I think that that would be a collateral attack on everything the ETA is designed to do.
Well, Sierra Club should express that position then in briefing and use that phrasing. That's a pretty emphatic statement. Let's see. Anybody else on that issue? Okay. I guess let me switch that issue. I'm going to make issue number 5 issue number 4 now, since I may have placed it out of order given Mr. Gerhardt's prescient observations. And this goes to, now I'm going to discuss that issue that I said that was issue 5, which is now basically issue 4. Remember my discussion with Ms. Sanchez where she said that pursuant to the state XREL e-golf decision from 2020 that I cited, that the commission is required, and now I'm going to refer you to sections 6218-4 and 6218-5E as an Edward of the ETA, where in section E, subsection E of section 5, it says, if the commission finds that a qualifying utilities application does not comply with section 4 of the Energy Transition Act, comma, the commission shall advise the qualifying utility of any changes necessary to comply with that section and provide the applicant an opportunity to amend the application to make such changes. This is something I discussed with Ms. Sanchez. I think I referred to it yesterday again, because it refers to section 4, and it doesn't refer to section 4B precisely. It just refers to section 4. And as you know, in section 4A, the ETA says, quote, to obtain a financing order, comma, a qualifying utility shall obtain approval to abandon a qualifying generating facility pursuant to 62-9-5 NMSA 1978. So, Mr. Gerhard anticipated the point that there's a, if you will, a conclusion, a condition precedent to a financing order, condition precedent, and that is a finding that the abandonment should be approved, that there is a net public benefit, and that the transfer, that there's no net detriment. Remember the transfer provision. Interestingly, 6295 is cited here, but not 62-6-12 and 13 from memory that required the amended application that I allowed. So remember what I said there. Well, arguably, PNM has already been given their guidance on that is called for in section 5E with regard to the abandonment aspect. So in 5E is the legislature talking about the specifics for an application for a financing order, that it shall include under section 4B, the 13, is it? The 12 enumerated items, or actually it is, there are a whole bunch of enumerated items. There are sub items, but basically it's B1 through 12. So having gassed on about issue number 4 for a while, I'll step back and see what any input I might get from the parties on this issue. Mr. Gifford?
Yeah, Your Honor, I think, it's been framed. I certainly have we have our position. And I think you've heard. We've learned that Mr. Gerhardt in law school sat in the front row and raised his hand a lot, I think, but that's good to know too.
But Mr. Gifford, so I don't want to impinge on PNM's right. If, like, for instance, if Ms. Beatles advocated a position, you're certainly free to raise your hand and say, we want to parry with that, or we want to record our position. We want the hearing examiner to hear this now too, even before the briefing. Even though it's not argument, I'm not taking away anybody's right to provide a response.
No, and I think this might be an issue, a rare issue where we agree with Ms. Crane and others that there is not the opportunity to necessarily undo what has been securitized, that once you securitize it, it's done. That would be our provisional and conditional view, and I think one we've already expressed.
Yeah, and I understand. And what my concern is mostly is that when you see that issue in the brief in chief, that you provide a crisp, solid response to it that I can understand. That's all. That's the most important thing for me right now. So, okay, anything on issue 5, Ms. Nazi?
Thank you, Your
Or
Honor.
issue 4, excuse me, I think it's issue 4. Go ahead.
You know that I raised this with Ms. Deschanel, I think, specifically. And I think that if Your Honor finds that abandonment is not in the public interest, that the ETA applies in this case, pursuant to State versus XREL EGOF, that then you may say that the pursuant to Section 5E, that requires Section 4 compliance, that if you find that there's not a net public benefit to abandonment, then you can state that PNM's application does not comply with Section 4 of the ETA because PNM has not met its burden to prove that its application is a net public benefit to New Mexicans or consistent with the factors and requirements set forth in the commuters committee case for abandonment pursuant to Section 62-95 NMSA.
Yeah, and I understand that. Thank you, Ms. Nazi. My concern is that it seemed there was more to that. There's more undertow there that might suck an unwary hearing examiner, unwary or not particularly alert hearing examiner under the current there. Because PNM seemed to be suggesting that it's entitled to a financing order along with the findings on abandonment. And all I would say there is that, a query, why would the hearing examiner recommend and issue a financing order if the findings under 62-18-4A indicate that abandonment is not in the public interest? And to assuage some people's concerns that they might not be able to convince the commission that the hearing examiner were wrong, well, there is a model financing order out there. There's one in the record that purports to comport with and comply with the requirements of the previous financing order issued in case number 19-00018ET. Short of that, if you're not successful in convincing the commission on your first foray, presumably before filing an appeal at the Supreme Court, one would try a motion for rehearing. And are we back in another case that we've been discussing quite a bit? And that's all I'm going to say on it, and I'm going to keep a smile on my face. Okay? It's a real smile. Seriously. Okay. Is there anything more on that issue? That's issue 4. I said 5. I was wrong. It was issue 4. Okay, now going to 5. And this gets back to where Mr. Gifford was talking to Dr. Fisher a little bit today, and I was talking to Mr. Graves too a bit, and you guys cross-examined Mr. Graves on it as well. Assuming arguendo, italicized arguendo, the commission still retains the authority to perform a prudence review of the
I'm
undepreciated.
sorry, Judge, I lost you.
Assuming arguendo, the commission still retains the authority to perform a prudence review of the undepreciated Four Corners investments, the hearing examiners found imprudent in case 16-276. What, if any, remedies supportable in the record would the commission have at its disposal? I'll stop there, at its disposal. And, we talked about a refund to ratepayers, a clawback, a disallowance, write-off. That's looking backwards, or the potential disallowance looking forward as well. The stopping or turning off that spigot Ms. Crane talked about regarding the unreasonable investment or investments. And to the extent that you can, please do put money figures around that. Please provide monetary quantifications of such remedies. Obviously, the numbers will be quite different coming from PNM than they would from some interveners. And around this, Ms. Beatles, you asked Ms. Crane about a regulatory liability. I don't know if it's pertinent to this or not, but I noted that you asked her about that as well. So that's basically issue 5 is the remedies. Again, assuming arguendo, that assuming for the sake of argument that the commission can perform a prudence review and can take whatever recommendations I might is emphasized, make on the issue of prudence. Okay, Mr. Gifford.
Assuming that arguendo, we believe that is certainly one of the issues.
Okay, thank you. Ms. Beatles, you had your hand up. That's why I'm asking.
A question. Following up on that last issue, you're interested in not only what rate mechanisms are available to the commission, but also what associated amounts would be supported by the record.
Precisely.
Okay.
And I'm not just calling on you as a special student or special counsel. You have your hand up, and so I see that and I call on you. Ms. Nanazi, did you raise your hand?
Yes, sir. I'm curious about this in light of some specific words, which I would like to just refer to in the 16-276 order, paragraph 66. It says a more full opportunity for the commission to consider the necessity and scope of any remedy in light of PNM's alleged imprudence. So what I want to raise with you is, in this section, does this raise the question potentially that if PNM has admitted that currently Four Corners is not cost effective, which I think is the evidence here compared to other resources, is a possible part of the remedy it being excluded from rates? Like what hearing examiner Glick, I don't have the exact reference, but I can pull it up, stated in her 15-261 order, in her corrected recommended decision. And I could tell you the page if you want, or if people need it. So that's would this be an appropriate place to include such an argument?
I'm reading the real-time transcript because it's pretty complicated, Mr. Nazi, what you just set out. So don't take my silence as anything other than trying to figure out what we're talking about. Because you started off talking about the revised final order, paragraph 66 and 16-276, right?
Correct, sir.
And for the record, that's the commission's January 10th, 2018. Revised order partially adopting certification of stipulation. It's paragraph 66 on page 23. There's some other, that's an interesting paragraph that y'all should focus on. That goes back to what precisely the commission did there, right? What it found merit in, the benefits to ratepayers. And then read into paragraph 66, what did the legislature provide an answer in the ETA? There. Were people reading this pretty carefully when they went to the legislature? Again, genuine smile. And at the end of that paragraph, you'll note that's where the commission said it would take administrative notice of the evidence on the issue of prudence admitted in the current proceeding. I don't know how to respond at this time to that, Mr. Nazi, but I'll take any viewpoints that the parties may have in relation to your question.
If I could just also just say for the record, it was the corrected recommended decision, August 15th, 2016 in NMPRC case number 15-261 at pages 110 through 111, which I do think also was discussed in the New Mexico Supreme Court case, PNM versus PRC, that you mentioned before, this issue as well.
Well, and bear in mind that that's an important decision, as all Supreme Court decisions obviously are, but this one's important in this case, both with regard to the prudence review. I think I made that pretty clear in my discussion with Mr. Graves. So if there's nothing on that issue, I'm going to move to the next one. And this, Ms. Beatles, I haven't forgotten about the bots issues. So that's coming up. The witness bots raise some issues that I think that I want to make sure that the folks brief. But before I get there, there was another issue that came up that Mr. German was at bat for PNM on, and that's regarding, well, I'll just read what I have in my notes regarding that. And it's pursuant to section 16 of the ETA. This is where we get into those sections, excuse me, section 16 funds, section 6218-16. How do the energy transition bond proceeds actually end up in the three funds: the Indian Affairs Fund, the Economic Development Assistance Fund, and the Displaced Worker Assistance Fund? Where all three funds consist of, quote, appropriations, gifts, grants, donations, and bequests. Those funds that are administered by the respective state agencies. Is legislative appropriation somehow required as a legal pass-through? What mechanism is required to provide the agencies the bond proceeds into the funds the agencies are delegated the responsibility to administer and provide the, quote, disbursement of money, quote, from? And it's interesting that the legislature there uses disbursement of money from, because it cross-referencing section 2H4, H as in Horatio, 2H4, section 62-18-2H4. It includes as energy transition costs payments required pursuant to section 16 of the ETA. Mr. German did not have and I didn't expect him to, and there may not be a ready answer to this question. That's why I raised it. Any observation, Mr. Gifford?
No, I again, Your Honor, I think it's an issue that is worth framing. And I have no modification to your framing of it.
Thank you. Anybody else? Okay. Now going to what I labeled the, I guess I should say, Western Resource Advocate / bots issues. I think there are some that require attention there. And first off is the proposed adjustments that would limit the securitized energy transition costs to $230 million. First off is that 27 million or 27.9 million adjustment to beginning plant balance to FCPP. Please analyze the provision of the modified revised stipulation, paragraph A, that requires PNM, well, let me rephrase that. That PNM asserts requires Mr. Baker's treatment regarding, quote, any accounting requirements under GAAP affecting the valuation of the assets on PNM's financial statements that may result from that paragraph A shall not affect the rate base value of the disallowed investments, capital D, capital I, for purposes of setting retail service rates. He also has another recommended adjustment to ongoing capital expenditures. So that's the first issue. Now, the second issue is related to the seasonal operation agreement amendments. He cites, that being WRA witness bots, cites article 6.1. lowercase d dot lowercase I. And here I want the parties to reference the sections of the proposed amendments where the seasonal operations agreement provisions are found. WRA proposes, according to Mr. Botz's testimony, that be stricken or modified so that, quote unquote, plant owners should continue to have the ability to vote for early closure of FCPP at any time. That's the second issue. And then sub-issue C, I guess, or issue 3 is because the first issue has 2 parts regarding those recommended adjustments. The last issue is whether the commission has the authority to approve the purchase and sale agreement and the amendments comprising the seasonal operation agreement. Is approval even necessary for approval of the abandonment and transfer of PNM's interest in the FCPP? Again, abandonment 62-9-5 and transfer, sale and transfer, calling into question the other analysis pursuant to, I believe it's 62-6-12 and subsection 13. To effectuate the transfer, assuming arguendo that abandonment recommendation is made. Anything on those issues? I think it's pretty self-explanatory. I just wanted to make sure that the parties brief those issues. Ms. Beatles?
Mr. Hearing Examiner, I just wanted to clarify that you said it was Article 6.1 DI of the seasonal operations agreement, but I think we're referring to the NTEC purchase and sale agreement.
Okay, right. That's what. But in discussions with Mr. Falgren, it's those seasonal operations agreement amendments aren't just in the NTEC PSA. There are amendments that affect the whole supply. I just don't want to lose the other amendments or have those amendments fall through the cracks, assuming that it is a recommendation were made. There are other amendments, right, to the coal supply agreement.
But I don't know that, I mean, those amendments were not made when the PSA was executed, is my understanding. PNM could correct me, that the amendments came afterwards, and they're amendments to the operating agreement, the co-tenancy, and the coal supply agreement. But those were made and executed after the PSA with NTEC.
Okay, Mr. Gifford, can you enlighten us on this issue?
Yeah, I believe that's true, and I think that the record does make that clear, that the PSA and the seasonal operating agreement, for instance, came after the PSA, but we'll, among other things, be sure to make it clear and it should be clear already in Mr. Falgren's testimony, but in our briefing and how those mechanics work and fit together, we'll certainly bring that forward. But I believe that Ms. Beatles is right in how those agreements were sequenced.
Given my observations about this, Ms. Beadle, does that clarify for briefing what the recommendation would be?
Yes.
Okay. All right, now the next issue is, and it's actually related to the last question, and this is something that was touched on in the cross-examination of Dr. Fisher, is related to the very last question, is whether the seasonal operation agreement amendments will hasten, H-A-S-T-E-N, delay, or alternatively accelerate or have no effect on the potential ultimate retirement of the Four Corners power plant. For example, some witnesses like Dr. Fisher and I believe WRA witness Botts and my examination of him suggest a 2026, 2027 timeframe. So just generally, and I guess even, well, that's that issue, focusing on the seasonal operation agreement. And let me go to the next issue, which is related more broadly, and again, related to the more specific focus on that last question regarding the seasonal operation agreement amendments. What scenario, if any, would cause the earliest retirement or alternatively delay an early retirement? Approval of the application on one side, Sierra Club, Dr. Fisher's recommendation on the other, or any other recommendations made in between that can be found in the testimony. That's just a broad-based, or broad-brushed, if you will, observation on the ultimate objective of the retirement of the Four Corners power plant. And those issues may not be well framed, but I take that from the testimony, though, that if you do this, it's going to delay Four Corners retirement. But so anyway, I'll take Mr. Gifford. Do you have any input here?
No,
Should
maybe
this stay out of the briefing order?
Again, Your Honor, first and foremost, if you're interested in the issue, we're interested in the issue. I think, and maybe I'm just stating the obvious, which I'm sometimes good at, by what you're putting in the briefing order doesn't limit us or any party from briefing or framing the issues that they see relevant based on this record. Is that correct?
No, nobody. That's correct. Nobody's going to frame, even look at the decoupling case. Even though I framed the issue specifically, people reframed them the way that they wanted to frame them.
Indeed,
right?
That's been known to happen, Your Honor.
So I'm not expecting, nor would I really necessarily want, a verbatim recapitulation.
Understood.
But I want to make sure I understand the case first off, and that second, I'm asking the right questions. And I'm not sure those are the right questions, but folks have argued that if you adopt a seasonal operation agreement, that will delay Four Corners retirement. And if you, Dr. Fisher's position, if you approve the abandonment, it will delay Four Corners retirement. I'm kind of shrugging my shoulders here. The record can't see that, but I just described it, so take it for what it's worth. Anything on those two issues, Ms. Beatles?
Yes, Mr. Hearing Examiner, you implied a regulatory treatment that I asked whether you want to be addressed in the briefs, and that is an option available to the commission that it could approve the abandonment and securitization, and at which point the plant is no longer jurisdictional plant. PNM has the option as a business to sell its asset, and that sale doesn't require commission approval. I don't know if that's what you were raising.
Oh, gosh. I don't think, no, but again, that doesn't mean you can't brief the issue. That seems to go back to the proposed remedy. Proposed general remedy, right?
And there's been a number of water utility abandonment and sale cases where the sale is to an unregulated entity and that transfer still is subject to and bears the scrutiny of commission review and approval. So I'm not suggesting that that is something that I would argue, I'm just raising it.
Well, jurisdictionally, the sale is to not only, it's to an entity related to a sovereign nation, right?
Yeah. Mhm.
That's one of the sensitivities here. And as I said at the pre-hearing conference, bear in mind where the plant is located, right? Okay. You know, and I guess I want to understand the parameters of around the seasonal operations agreement and just generally pay particular attention to, on one side, what Mr. Fogland argues regarding what's required for early closure and the realistic prospects for that versus what other parties argue in relation to that. We had some discussion this morning about that between Mr. Gifford and Dr. Fisher. So the only other, well, the waiver issue, Ms. Beatles. I don't know, you're free to argue it. I'm not sure how to frame it, but I guess obviously I'll be looking for that. That may be in terms of go back up to the remedy. I'm not sure. The remedy question. Ms. Beatles?
I do have a framing, and that would be whether PNM waived its right to assert full recovery under the ETA when it implemented the rates approved by the order in 16276 that included a deferred prudence review.
That would be a tacit waiver, wouldn't it? Implicit waiver. Tacit, T-A-C-I-T. Right?
As opposed to an express waiver.
Where was the express waiver? If there is one pointed out to me.
Okay. I'm just asking, as opposed to, you're saying tacit as opposed to an express. And if I do think that if I do maintain that it's been expressly waived, you certainly want to be made aware of it.
You maintain it's expressly waived. Well,
no, not necessarily.
Oh, you don't?
Yeah.
That's why I said tacit or implicit waiver, or by agreeing to the benefit of the bargain, which is, this goes back up to the contract issue perhaps, but I think that goes back up to, I'll consider that. I'll have the rough draft of the transcripts and I may move that issue up after the remedy issue for you to address. But my concern there is, one might ask, and I'm just, it's kind of like a law school question. The question, the answer, so what? The ETA took care of whatever benefit of the bargain or waiver that PNM may have implicitly made, right? Because the legislature stepped in and answered the question, going back up to paragraph 66 of the revised final order and related provisions of the revised final order. That might be a yes, but the ETA let's just say address that. Yes, sir.
Yes, I think there's a second waiver issue raised by the evidence. And I would point to the rebuttal testimony of Thomas Faker at page 5, lines 4 through 15. And that is where PNM opposes Mr. Bott's reducing the amount of undepreciated investment subject to securitization. And PNM says that's contrary to paragraph 8 of the modified revised stipulation, and goes on to say because the signatories agreed and the commission approved that the rate base value of the full 148 million capital investments would not change as a result of the impairment, WRA may not now seek to reduce that amount. And this stands out to me because throughout the case, PNM says, we don't care about what happened in 16276 because the ETA has superseded that. And yet, PNM seeks to use the outcome in the 16276 case as a sword and a shield. In this instance, as a shield, say you cannot act inconsistently with what you agreed to in this stipulation as approved by the commission in its final order. So that raises the question whether if PNM is seeking to enforce the final order, doesn't that mean the commission also has to enforce other provisions of the final order that also impact how much PNM is allowed to securitize? And I say because what Mr. Botts disagrees about with PNM is the inclusion of FERC account 435, which is the undepreciated unamortized loss resulting from the write down of the plant balance. According to the stipulation in the final order, that amount should be added back into the balance because it's still on PNM's books and records. Never mind that it may not be undepreciated investment in PNM's books and records, it's on the books and records. So PNM is asking the commission to enforce the stipulation. So how is that consistent with PNM saying the stipulation does not apply in this case? And
Well,
again,
that goes back up to that 27.9 million and for that adjustment. And that might be a salient point to be made with instead of me framing a separate issue, it may be a salient point to focus. Yeah, I understand what you want to do with it. You want to make a broader argument about sword and shield. But you might focus on, make it separately, frame that issue, or make it a subset to the waiver issue, or whatever. But it also may be fruitful for you to address in the context of that recommended adjustment.
yes.
Now,
So, I mean, if you don't mind, if I could just add one thing.
go ahead.
Sure. I just want to make sure that it's understood this is a distinct waiver issue from the initial one, which is based on estoppel. And did PNM's actions at the time allow other parties to rely on it and create a situation where PNM's precluded from acting inconsistently? This is different. Waiver is the voluntary relinquishment of a known right. And so to the extent you were asking Ms. Beatles about her waiver argument, didn't the legislature's passing of the ETA kind of say, so what, to what happened there? But this is different because the commission could say, yes, the ETA did preempt the 16276 settlement and order. However, due to PNM's conduct, their voluntary relinquishment of a known right and arguing for the commission to enforce the stipulation, that is a waiver that happened through that action of PNM in this case.
It's not a waiver. It's you're arguing PNM as a stop.
No, it's different from us. No, I'm not arguing that at all. A waiver is focused on the conduct of the party voluntarily relinquishing a right they otherwise have through their actions or conduct. Estoppel focuses on the reliance of other parties in insisting that conduct should not be taken in the future in that contradicts what parties relied on in the past. The waiver is something that happened after the ETA was passed, and in the context of this case, in asking the commission to enforce the modified stipulation. And again, that's based on Mr. Baker's rebuttal testimony at page 5.
Now, and again, focus on the fact that the magnitude of what, don't take seriously what the ETA did here. Whether it actually modified in some limited instance, in this particular instance, the regulatory compact in a way that the legislature may have tried to do, maybe less specifically in other statutes at around the same time. But what it did here is pretty specific.
Thank you.
Would you disagree with that, Ms. Zer?
No, I would not.
So you're proposing an estoppel issue.
Are you asking me again? I don't know if you're.
Yes.
So no, I'm not proposing an estoppel issue. I will assert that waiver and estoppel are different. And the waiver is, I'm proposing a waiver issue based on PNM's attempt to enforce the ETA in this case. That is, enforce the stipulation terms in paragraph 8. That conduct may establish a waiver of PNM's right to insist that other terms of that stipulation should not also apply. Does that make sense?
Please brief that back. I just please brief whatever you think is appropriate there with regard to the waiver. And then if you have an estoppel argument, obviously this is a non-exhaustive list. If you don't see it in the list that I put out in a briefing order, assuming I do, and you don't just look at this discussion, if I run out of time, don't be disappointed. It doesn't mean, it may mean that I didn't fully grasp it and that I'll have to see it in writing. So, yeah, I guess I had asked also whether, and this is a separate issue, whether New Mexico area's witness Dauphiné, whether there might be, even though this testimony was stipulated into admission, into evidence, whether there might be an issue there. Mr. Gould?
Yes, Mr. Hearing Examiner, am I off mute? Okay, I am. Yes, we have taken limited time in this case, and we filed on limited issues. So we're simply, of course, I have to go draft a brief and run it by my membership first. But if there's something specific on Mr. Dauphiné's issues, they just had to do with treatment of some very discrete costs that have come up in this case. Otherwise, I think his testimony is self-explanatory, but if you need us to address it in more detail, we certainly can.
No, just make sure that you highlight those recommendations.
Thank you.
On costs.
Okay.
Like we did in 1918. I just don't want things to fall through the cracks.
Thank you. Appreciate that.
You're welcome. Okay, the final issue, and my better judgment tells me I shouldn't raise it, but I think that from what I've heard today, and perhaps yesterday, but certainly today, it's something that the parties paid attention to. And that is whether Mr. Graves' apparently unprecedented, at least in terms of a utility regulatory proceeding, ex post damages analysis, which he appears to have conceded is a hindsight study, is an opposite and at odds with the prudence standard. Is there anything, Mr. Gifford, you unmuted yourself, go ahead.
Well, I mean, Your Honor, we'd certainly take issue with the characterization of unprecedented and inapposite, and we're happy to tell you why that's not so under the relevant standards. But
yeah, I mean, the parties have called it worse. And I'm just parroting back some of what I've seen, and it's that and that's why I say apparently. I don't, you know, you as well as I were taught not to use adverbs and adjectives wastefully. So when I say apparently, I mean, you know, or I don't like to use allegedly. I like to use allegedly in a slightly different context, but that's inside baseball. I'll step out of that right now. But go ahead.
No,
Go ahead.
yeah, obviously we take issue with the characterization, but as you know, one of the issues, it's certainly out there, and we have seen it and disputed it, and we'll continue to do so.
Yeah, and the other issue, and I'm not going to hide it here, is whether his ex ante analysis actually makes what PNM didn't do look worse than it did when we addressed it in 16276. But, you know, I'll just make an observation I already emphasized with him in particular. So there's that as well. But you won't see that. In fact, I raise it here. It's in the transcript. You all should brief it. I may not even include that for reasons I won't go into here. So if you don't see that issue as number 12 or whatever on the list, it's not because I'm not interested in it. It's just something that I don't feel comfortable just quote unquote, making an issue, if you will. Okay. Is there anything else? That was it's not an exhaustive list, but it's a pretty detailed list. I will concede. And you've been all very gracious in taking the time to address them with me. So if there's nothing else to address right now, I will set the briefing schedule. And before I do, though, are there any proposals for briefing that the parties have discussed?
Your Honor, I can represent that we have not discussed them collectively. But if you're open to some opening bids, I'm willing to offer some dates if you indulge that.
Yes, and I'm aware that when you do this, that you are expected to file briefs in the merger case, main briefs, so briefs in chief on September 21st, is that right? And then in response briefs on September 28th.
Correct.
So, and I obviously want to be consistent with what you all are dealing with in the merger case. So, Mr. Gifford, do you have a proposal?
Yes, Your Honor. We're working backward from I think it's December 15th decision date or deadline date for the commission. And at least we started with, and this may be difficult given the parties' participation in obviously multiple cases running in parallel, but to give you adequate time, which we certainly want to do, we would propose October 1st as the initial brief. If you think, and if the parties think, if you think you can compress that, we would propose moving it to October 8th. But October 1st, we think is probably the sweet spot we need to hit for the opening briefs. And then reply briefs 3 weeks later, or even October 15th would also work for reply briefs.
If I may, Mr. Hearing Examiner, Brad Borman speaking. October 1st is currently scheduled as one of the days for PNM's RPS case for its hearing. So that is clearly not going to work. I would say no earlier than the 8th.
And Mr. Hearing Examiner, I'd point out that another PNM case involving Palo Verde, when does that start? The 20th, October 20th. So all we have are PNM cases.
Yeah, maybe they might want to pick their spots and figure out what's important, huh?
Palo Verde is the week of the 18th for your honors purposes.
Mr. Borman,
Yes,
the RPS case,
yes.
how involved is that? What can the commission expect from staff in that case? That would conflict with getting briefing done in a timely way that I can get a decision to the commission, because quite frankly, you were quite emphatic that it won't work, but I'm not entirely persuaded that it won't work.
Well,
that was the date that I was good. Let me finish, because October 1st was the date that I had penciled in for briefs in chief.
Well, I'll just give you my personal reasons for why that won't work. We have, as you had pointed out, we have briefs due on the 28th in the PNM Avangrid case.
Response briefs.
Pardon me?
Response briefs.
The response briefs are due the 28th. That's correct. I will be out of town actually the week from the 17th through the 24th. Because I've had 2 straight hearings with these guys and have another hearing scheduled the 30th. I need to take some time. And so with those briefs there and the hearing, unless you want me to prepare a 3-page brief, which is I'm more than willing to do. I mean, I just don't know. As Ms. Nanasi said, there's just not enough time in the day right now. These guys had the choice of what to file and when, and they didn't have to file this case, but they decided to, and here we are. And so I don't see why everybody else has got to be pushed to get PNM what they want as soon as they want it.
It's not what PNM wants, it's what I need in order to get this case to the commission in a timely fashion, that they don't turn around and say, well, you only gave us X amount of days to look at this from the recommended decision. And am I going to turn around and say, well, I was trying to accommodate the parties? What response am I going to get back on that?
I recognize that. I recognize your dilemma.
Thank you. So briefs in chief shall be due October 1st. And I will allow for response briefs to be filed by hearing examiner Shannon. Will only give you a week. I'll give you until October 13th. for response briefs. That's giving you a little more additional time in a case that is about, it's probably, I don't know, I'm not going to mischaracterize the merger case and all the issues that are in play there. But there are lots of significant issues here, but I need good briefing, but I also need efficient briefing. So October 1st for briefs in chief, and response briefs due October 13th.
And Your Honor, if I might propose an addition to that briefing order that we make corrections to the transcript due on that same day of October 1st when the briefs in chief are filed.
Isn't there a deadline in the rule for corrections?
There is.
That I can vary, but isn't it? I read it yesterday. Was it 13 days?
13 days, Your Honor.
Okay.
And this would follow the rule that I believe is being followed in the merger case. But
yes, then I will make provision for suggested corrections to the transcript be due on the date that briefs in chief are due.
Thank you, Your
Thank you, Mr. Thank you, sir. Okay. Is there anything else to address? Ms. Donazi?
I just wanted to ask you that if you know now, if there's going to be a shortened time for exceptions and a response to exceptions, or is it going to be according to the rule?
I don't know.
Okay.
I honestly don't know. Thanks for the question. Ms. Beatles?
Will you be issuing a briefing order, or should we be referring to the transcript from this day for a listing and description of the issues? Or both?
I'm not sure yet. Both. I'm not sure yet. I put you through this exercise. I'm more likely will try and frame the issues in the briefing order. But if I could still throw my hands up and say, you know what, it's in the transcript. But I'm leaning toward a more detailed briefing order, but we'll see how it looks. But you do have, even if I didn't do anything else and didn't issue a briefing order, you have basically your marching orders, right? But I do intend to put out a briefing order, which, you know, has briefs in chief due October 1st and response briefs due October 13th. Is there anything else to address before we close the hearing? PNM?
nothing from us, Your Honor.
Any intervener? Staff?
Thank you.
I want to thank you all for your indulgence and excellent participation in this hearing. I know it's under trying circumstances. I'm sorry for that, but everybody stuck with it and did well under the circumstances. And I thank you all very much for your engagement and participation in this hearing. And well, very well. If there are no other matters to address at this juncture in the proceedings, this hearing is concluded. The evidentiary record is closed, and this matter is taken under advisement. Thank you all.
Thank
Thank you, Your Honor.
Thank you.
Thank you.
Take care, all. Mr. Lee, special thanks to you. I meant what I said before. You're the greatest court reporter going, and I truly appreciate you so much.
You bet, Judge. I'm happy to help. It was a privilege to work with you.
Thank you. Oh, no, it was my privilege, certainly. So we'll talk after this. I know this is off the record now. We're still obviously on YouTube, but we had another hearing issue come up that Anna may have talked to you about
Yes, sir.
that I won't go, but I will. I definitely will make it happen. Let's
All
just
right.
put it that way.
Thank you, sir.
Thank you. Thank you. Thank you for alerting me to the problem.
You bet.
Ms. Beatles?
Yeah, I just want to add that Mr. Lee has a future in utility regulation. He's
Thank you, Ms.
catching
Beatles.
on- He's catching on real quick.
You'd be amazed looking at real time how quick he does. It really is a remarkable thing to see in quote unquote real time. So anyway, but it goes beyond that. It goes beyond that. But I'll just let you all go now. But thank you